uh, 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 Zoom casual or something like that. What do they
Yeah.
call that? Yeah. Okay, so we are live now.
Maureen, was there anything in Hazelcrest or Country Club Hills?
You know, I could not believe it. I even had to double check with John.
Yeah.
But no, nothing.
Really?
Unless they had like another attorney handle the board and he had his own reporter or something, but
No, John wouldn't hand that off.
No,
He would keep, how about Richmond Park? No?
Nothing there. And I didn't do anything. You weren't involved in Matson, but I didn't do anything out there either. And those are usually always.
Well, Country Club Hills always. And
I know I emailed the secretary. I'm like, this is like, a quadrennial. There's just no question.
yeah,
but,
the Hazelcrest also was, in the past couple of years too. Well, that's good. How about Olympia Fields? Nothing.
I'm headed there tomorrow afternoon.
Oh, really? Now that's the first.
6 cases.
Is it for mayor or for alderman, trustees? Do you know?
I think there's 2 cases for mayor and maybe 4 cases for trustee, and John did get them consolidated. So it's 6 cases down to 2.
Interesting, because the whole time I was with John with Olympia Fields, we never had any objections filed. So
yeah,
you're getting ornery down there.
yeah. Well, another week or 2 for me, and this will all just be a bad memory. So, and every 4 years I say I won't be back for the next one.
It's not 4; it's every 2 years.
Well, yeah, but I don't know. It seems like that in between year isn't quite as bad as the one after a presidential election. It just seems, to me anyway, I don't know.
I've had a lot of townships this year. Usually townships aren't, as active.
Yep, I have one of those finishing up today down in Kankakee. So
Kankakee. No, I've had 4 townships. It's like, really, guys?
Yeah. I think you were out on Linwood with.
I was at Linwood, yes.
Yeah, I didn't. I was covering them, but I didn't actually do any of the reporting on those. So I missed you there.
Yeah.
But I knew you would pop up somewhere, Judy. I just knew it.
Well, because I'm not the attorney for a lot of the, John's villages. I have more time to be public member this time around. Usually I'm the attorney, so.
Right.
Okay, we have Dan Kelly. Dan has to unmute. And Scott?
All right.
Morning.
Morning, Dan. How are you? Good morning, Scott. All right, we're just waiting now. Steve is on the screen, but he has to unmute. And then Bob Bertucci, and then Domingo Vargas has to get back to his screen.
I don't know who Com Arts is. Could that be someone?
Sorry, what?
I mean, I'm just one building away. Okay. If first come to first pass, I can shoot on. Yeah, let me just sign in. Here's Alderman Dexter Johnson. He's with you too. How are you, sir? Hey, Steve, how are you? Great. You're hanging in here with these, whatever the guys need. That's the board, a lawyer, representing Randy, myself. Okay. All right. Thank you. All right.
Alderman, do you have the Wi-Fi password for her?
I do. I do.
Oh, hey,
Um,
Randy.
Hey, how you doing, Steve? It's court with a capital C, C-O-U-R-T, and it's 1235. And I believe it's that Linksys one with the highest bars, if you will.
Do you know the name of it by chance?
No, I think it's called Linksys.
Okay.
Bob Bertucci, can everyone hear me?
You're muted, Bob.
Hey, how do I unmute?
We're waiting for
Start.
Dexter.
Star.
Unmute.
There you go. Star 6. There you go.
All right, I'm unmuted. Can you hear me?
Gotcha, Bob.
Okay, thanks.
Hi, Bob.
Hi, how are you?
I thought we had decided it was Zoom, but you're down there?
Well, in our conversation, I indicated I would, be coming here since it seemed like we'd probably accomplish something of substance, and last time was a bit of a fiasco. But the emails did seem to indicate Zoom. I didn't know we were all going to do it.
Mhm.
Yeah. Call me if you can't get on, okay?
Is that Steve?
All right.
Are you on, Steve?
I'm on. Yes.
Okay.
I just talked with Dexter Johnson. He's trying to log on right now as we speak. So,
He's in the room with us.
morning, Bob. Morning.
Morning, everyone.
Good morning.
There's Mayor Vargas.
Good morning,
Oh.
everyone. Good morning.
Morning.
Scott Erdman looks like he's muted.
Mm-hmm.
I am. I usually stay muted until it's my turn to talk to cut down on background. So.
Thanks. All right. I learned something.
It's always, it risks the danger of that clicking on it repeatedly to get it to unmute while people are waiting for you to say something. But,
Well, and
You're just worried about the hot mic issue.
yeah. And I don't know if everyone knows, if you're on a PC and you have a keyboard in front of you, that if you just hit the space bar, you're muted and you hit the space bar, it temporarily unmutes you, and then you let go of the space bar, then you don't have to keep clicking mute, unmute.
There's a big screen here we were going to try to use, but we don't have anyone to help us out. It doesn't look like it's on.
No.
So we're just going to use our iPhones.
Randy, thanks for that. I didn't know that. That's
That's a good one. Like I said, we've been doing these since the very beginning, and my little like Judy said earlier, the tech guy, I learn a lot along the way.
You send out a little memo to us on all these.
Yeah. All the little tricks.
So if you hit the space bar, it'll unmute you.
Yes, and then let go. So if you mute first, mute yourself. And if you're only going to talk sporadically, you hit the space bar, talk. It's almost like keying remember the old police radios where you had to push the button and talk and then let go?
Sure.
That's exactly what the space bar does on Zoom.
like when the CBs were.
Yeah, exactly.
So we can keep on trucking.
Now I don't see myself
We
on
don't see
here.
you either.
Yeah.
You guys don't see me?
No, we don't see it. You'll have to. I don't know how to do it on the iPhone.
Okay, because I don't see myself. I don't see.
Yeah.
Steve.
You guys, you're too close to each other.
Steve and I are too close?
I'll go back.
When you
Okay,
hear-
and
when
I
you-
don't see you on here, Steve.
Yeah, I'm trying to not use video.
Okay. What if I want to use video? What do I do?
Ben, is there something you can do or no?
You're downstairs right now?
Yes.
All right, I'll come down there and show you.
I'm gonna try to reach out to Dexter, Jens.
You know, and have him call me, okay? I'll get him logged in on the computer, Carrie.
I think going forward, if Mr. Ladizinski and Mr. Bertucci are too close to each other, we're going to have substantial feedback issues. You really can't.
Yeah.
um,
Steve, I think was going in the back of the room. I think I heard him say.
Yeah, we will. Are you a tech person or? Oh, good. I mean,
To the TV station upstairs.
can we do this or not?
This right here?
Or how do I make myself viewed? That's me. Start video. Hi, everybody.
Morning.
A young man is helping us out here.
Yeah, that's Ben.
And
Bob,
Steve, what's his name?
Ben,
That's Dexter?
can you have Dexter call me?
Dexter Jackson?
No.
Yeah, he said in a second he's gonna call you.
Okay, great. Thanks.
Is
Okay.
Dexter gonna call you, Randy?
Yeah. I'm going to give him my login so he can log in on the PC. There's a for the camera there.
I didn't want to be visible for your benefit. I wanted to be visible so I could look at myself.
Oh, Hank Aaron died.
Who did?
Hank Aaron. The
Oh,
baseball player.
yeah. That's sad.
Yeah, he's 86. Anyway, that's the gossip for today.
It's Dexter calling in now.
Yes.
Yes.
Now, he and I are probably close to each other, but I don't hear reverberation.
Okay, is everybody on?
Yes. Yes.
Yes.
Very briefly before we get started, at approximately 10:25, Mr. Ladizinski, myself, and Mr. Erdman are going to have to leave this particular screen or conversation and zoom into a meeting or a hearing with Judge Taylor pursuant to a motion filed by Mr. Erdman. So we've got about 10 to 15 minutes to get started with respect to this particular proceeding. So with that being said, we can call the meeting to order. I think everybody that's in the meeting at this point in time should identify themselves. And,
oh, wait, Carrie, are we on the record?
pardon?
I haven't started reporting yet. Are we on the record, or was that just like a,
Well, my original comments did not have to be on the record, but we can go
Okay.
on the record now.
okay.
Carrie?
Okay, at this point in
Just real quick.
time,
Carrie, just a minute, please. How are you notified of the meeting? I don't have any notice of this meeting, like Zoom information thing.
how are we notified of this meeting?
Are
Of
we on
the
the record?
Judge Taylor.
Judge
Okay.
Taylor? Scott, you're muted. I can't.
I'm using the button trick. What notice did you get for the meeting before Judge Taylor? I don't have anything in my inbox.
I think my assistant contacted Judge Taylor's clerk. that's, I don't know what else to say. I mean, that's what I did, or my assistant did. Steve, do you have that?
Steve is muted.
Steve, you're muted.
Steve?
I
Unmute.
received an email saying it was up at 10:30. And that's the
Yeah,
notice.
I have the updated information that was confirmed by Judge Taylor's clerk. I mean, I can provide that to you. I don't have any.
That would be great.
All right, well, let me give that to you right now, okay? The ID is 953.
You email this to me?
Pardon?
Can you email?
I'll have my assistant do that, okay? I'm trying to stay on this screen and I don't want to mess this up, okay? Hold on. Yeah, go ahead. My assistant, D. Finn, will email it to you, Scott. Anyway, if we can go on the record at this point in time. My name is Kerry Horvath. I am the attorney for the Electoral Board, Municipal Officers Electoral Board for the City of Blue Island. I'm going to first read into the record an Open Meetings Act public notice so that, at least with respect to the public, they are aware that they should be advised that on December 11, 2020, the governor of the state of Illinois issued his latest statewide disaster proclamation relating to the continued public health emergency posed by the COVID-19 pandemic, and has further issued executive orders implementing further enhanced mitigation measures and restrictions. As such, pursuant to Section 7E of the Illinois Open Meetings Act, the rules of procedure and of this board, we have determined that holding a meeting entirely in person that is otherwise conducted in full compliance with the Open Meetings Act is neither practical nor prudent because of the ongoing disaster. To the extent necessary, this meeting will be conducted with the option to participate via internet teleconference and without requiring the physical presence of a quorum. We further find that due to the disaster, the physical presence of more than 10 people at the regular meeting location in an accessible, hygienic, and legally compliant manner is not feasible. Alternative arrangements have been made to allow the public to contemporaneously hear all discussion, testimony, and roll call votes via Zoom teleconference. All votes shall be conducted by a roll call vote, and a verbatim record of this meeting shall be made and maintained in accordance with the Open Meetings Act. All participants are hereby further notified that by participating at this meeting, they acknowledge and are informed of this meeting's public recording. This morning and into the afternoon, we will be conducting hearings with respect to the matter of the objections before the Municipal Officers and Electoral Board for the City of Blue Island in case numbers 2020 BIMOEB-01, 02, 03, 04, 05, 06, 07, 08, 09, and 10. With respect to, after I've made that introduction, if everybody involved in the hearing would state their name for the record so that the court reporter has it. I realize there are 5 different members of the electoral boards that will be hearing these matters. So if we would start with Judy and then move from Judy to Domingo to Dan to Scott to Mr. Bertucci, and then Scott, Steve, and myself can identify ourselves for the record. along with, and excuse me, and Dexter Johnson, and then we as the attorneys can identify ourselves for the record. Judy, would you start, please?
Yes, my name is Judith Coleman. I was appointed by, I'm a public member appointed by Judge Taylor, and I'm the chairperson for 2020 BIMOEB-01, and I think 02.
That is correct. And Domingo, would you identify yourself for the record, please?
Yes, good morning. This is Domingo Vargas. I'm the chairperson for, I guess, anything other than the 01 and 02. And good morning to everyone.
Mr. Kelly, would you identify yourself, please?
I'm Daniel J. Kelly, and I was appointed by the Circuit Court of Cook County to be a public member of the Electoral Board for cases 01, 02, and 03 of this Blue Island Municipal Officers Electoral Board.
And Mr. Bertucci?
Robert W. Bertucci, BERTUCCI, public member appointed to
You're
case
zero.
ending 2. And then 6 related cases, 04,
You're
05,
fourth for 10.
06,
Yeah. And then
8,
Mr.
9, and 10.
Mr. Johnson, would you identify yourself, please? Dexter, can you hear me?
You're muted.
Dexter Johnson, Senior Alderman, Blue Island.
And Dexter, you were appointed as a member for 01 and then BIMOEB 2020-01 and then 2020-03 through 010, correct?
Yes, everything but 2.
Okay. Now, would the attorneys identify themselves for the record, please? Mr. Ladizinski.
Steve Ladizinski, LADUZINSKY, on behalf of the candidate respondents.
Mr. Erdman.
There he is.
Mr. Erdman, would you identify yourself for the record? Scott, you're muted.
I was trying to use the button trick and it wasn't working this time. Scott Erdman on behalf of the objectors. Carrie, I'd like to quickly recess this so I can prepare for the hearing in front of Judge Taylor. I had no notice of that until you said that.
What do you mean? You had no notice. You were the one that noticed it up. I'm sorry. And then Mr. Heiser, would you identify yourself, please?
I'm Randy Heiser, City Clerk, the Zoom techie guy.
Okay, and then we also have a court reporter. Her name is Maureen Nagel. Members of the board, it's approximately 10:23. As I indicated in my initial comments, we have a hearing before Judge Taylor scheduled at 10:30. So as soon as we are completed with the hearing, we will come back to these proceedings. The nature of the hearing has been a motion filed by Mr. Erdman to try and stay these proceedings. We're going to await Judge Taylor's decision on the motion. At this point in time, if we could just briefly recess, and Randy, what would be the easiest way for us to all come back to communicate with you? Should everybody just stay on the line or stay on the Zoom, or what should we do?
I would suggest that, because there's no way, I mean, it'd be very difficult to notify the 10 panelists that we're back. So I will be happy to stay here while the attorneys recess and go to the hearing.
All right, and then what I will do is when we're finished, I will call you and let you know we're finished and we're coming back, if that's okay with everybody.
That's fine. Just a technical issue. Should we go out and then we would go back in the way we came in this morning? Is that?
If I'm going to stay on, I'm going to stay here. So whatever you're comfortable with, I'm going to stay here with this one going. I will probably stop the live broadcast on YouTube, but I will, well, I don't know. I'll talk with Ben about that, but I will keep this meeting open so that when you guys are ready, whether it be 5 minutes or an hour, I'll be here.
All right, so I,
Well,
Okay, and so at this
in that
point,
regard, Carrie, you don't expect it's going to be particularly long in front of Judge Taylor?
I don't expect so, Your Honor. I think it would probably be about a half an hour at the most. That's my anticipation.
Well, okay, I think I'm going to leave the village hall, but I'll keep this on.
Okay,
All right?
that's
So no
fine.
problem.
We'll make sure before we start
Okay.
again, we'll get back with you. All right, if we can have a
Yeah,
real
but I'll
quick
leave it
motion-
on and I'll know that you came on.
real quick motion to recess. Can we get a motion to recess until we come back? Would
I'll make a
someone
motion.
I so moved.
I'll
Made
second.
by
Alderman Johnson.
Domingo Vargas, a second by Mr. Bertucci. On that, we won't do a roll call. Is everybody in favor of that?
Yes.
Yes.
Aye.
Thank you all very much. We'll be back, okay?
thank you.
Thank you.
Capital One makes banking easy. I can pay bills while watching TV with the mobile app, have a latte while getting answers to money questions at the cafe, even use my 360 debit card to grab cash at over 40,000 fee-free ATMs while I shop. I wonder what other things I can do together to save time. Oh. Okay, meditating while driving isn't one of them. Bank online and
Just FYI for anybody listening, the motion did end, so we should be starting back up shortly, I would think.
Great, thank you.
Judy, can you hear me?
Yes, I can.
Okay, it was a lot quicker than we thought.
Okay.
Thank you very much, Dee.
Gary, that was a justice delayed is justice denied.
Yeah,
Texas two-step right through that one.
Yeah.
We made good time.
it was quick.
And Carrie, my confusion on the notices, when I spoke with Claire, her response was that she didn't even know if he would allow it, and that she would contact us if he was going to have the hearing, and just to motion it up, and that she would let us know if it was going to happen. That's all my confusion is to.
So she didn't get a hold of you, huh?
No.
Because I asked my assistant to just contact her, and so she did, and then she sent us the information.
She was, yeah, she didn't answer her phone when I called earlier, and she obviously wasn't at the hearing. So.
All right, well, no problem. We got past it. So, is everybody on?
If only everything went that fast, huh?
Yeah, no kidding. Okay, we have Judy, we have Domingo, we have Dan, Scott, Bob, Randy, Steve, and everybody is on. Steve is muted.
I'm here.
Are you on?
Yes.
Okay. Steve, you're on? Okay. Bob, you driving, huh?
What amendment is that? Is that the fifth you're talking about? What amendment? I have a driver. I'll say this. I have a driver
Okay.
that won't be identified.
Okay.
And 5 minutes from now, I'll release the driver.
Okay. All right, Randy, are you on with us?
Yes, I am.
Okay. All right, we're back on the record with, my name is Kerry Horvath. I'm the attorney for the Municipal Officers Electoral Board of the City of Blue Island. We're back on the record with respect to the matters of the objections filed in the 2020 BIMOEB-01 through and including BIMOEB 10. If everybody would once again identify themselves, starting with Judy Coleman. Judy?
Judith Coleman, I was a public member appointed by the Cook County Circuit Court. For hearings 01 and 02, chairperson.
Yes, good morning. Domingo Vargas, chairman for the Electoral Board hearings of 03 to 010.
Mr. Kelly?
I'm Daniel J. Kelly, and I was appointed by the Circuit Court of Cook County to serve as a public member of the Blue Island Electoral Board for cases 01, 02, and 03.
And Mr. Bertucci?
Robert Bertucci, appointed as a public member to serve in 02, 03 through 6, and 08 through 10.
And I think you were, Bob, I think you were appointed on 04 through 10. You're not on 03.
Yes, I misspoke. It's 04 through 6 and 8 through 10. I'm not on 3, and I don't believe I'm on 7.
7 is, yes, you are on 7.
Okay.
Okay.
It's the same issue as 4 through 10 in any event.
Yes. Yes.
Okay.
Kerry,
Yes.
is he on 2 and then 4 through
Yes.
10?
Yes, Bob is on the hearing concerning Domingo Vargas, And then he's on all of the hearings for the clerk, Mrs. Mitchell Brown, Hawley, Esparza Jr., Webster, Farnwald, McGee, and Trinidad.
Gotcha.
All right, lawyers, would you indicate that you're on for the record, please? We'll start with Mr. Erdman.
Scott Erdman, Erdman, on behalf of the objectors.
And Mr. Ladizinski.
Stephen Ladizinski, Laduzkinsky, on behalf of the candidates.
With respect to this is Kerry Horvath, with respect to the matters before the board this morning, BIMOEB and then BIMOEB 01 and then BIMOEB 03 through 10 all involve the same legal issue for decision as posited in the objections filed by Mr. Erdman's clients. BIMOEB 02 involves a record review, which is fact-based. What I'd like to suggest, if it's acceptable to the members of the board and also for the objectors, we can address BIMOEB 01 and 03 through 10 together with all board members participating, listening to the arguments to be presented, and then they can make separate decisions in the cases in which they're involved. If that is acceptable to counsel for the objectors and counsel for the candidates, as well as members of the board. I put that out there as a manner in which to address these as efficiently as possible in accordance with the rules. Would that be something that first I'll ask the members of the boards? Mrs. Coleman, would that be acceptable to you?
Yeah, I would make a motion for the purposes of argument only to consolidate the legal argument in the cases 01 and then 03 through 010. And there would be, and then separate decisions, but at least for the purposes of argument consolidation, for the legal matter only.
And Mr. Kelly, could you second that motion?
Yes, I agree. I'll second the motion.
And Mr. Vargas, would you agree with that motion?
Yes, I would. I agree.
Mr. Bertucci, would you agree with that motion?
Yes.
And Mr. Johnson, would you agree with that motion?
Yes.
Okay, then we'll conduct a roll call vote on that motion. Mrs. Coleman,
Yeah, it's not Mrs. Coleman, but yes.
or Ms. Coleman, excuse me. Mr. Vargas,
Yes.
Mr. Kelly. You're muted, Dan.
Yes, I agree. I vote yes.
Mr. Bertucci?
Yeah, but Terry, did we get an answer from the candidates and objectors' attorneys that they have no problem with it?
Mr. Erdman, could you respond to that first?
I see no issue with just consolidating just the legal arguments as board member
Thank you.
recommended.
And Mr. Ladizinski?
I have no objection.
Okay. All
All
right.
right,
So,
with that, my vote is yes.
okay, and then Mr.
It makes
Johnson,
sense.
your vote? Mr. Johnson, your vote?
Yes.
Okay. Well, let the record show then that motion has been adopted by all 5 members of the various boards that will be hearing the objections and pending legal arguments with respect to 2020 BIMOEB-01, 03, 04, 05, 06, 07, 08, 09, and 10. And also let the record show that counsel for the objectors in all of the nine cases and counsel for the candidates in all of those 9 cases have agreed to the consolidation with respect to the making and presentation of arguments. Now, as a brief matter, prior to these proceedings today, on January 8th, when the board initially met, it set a briefing schedule on the motion to strike filed by the candidate's attorney, Mr. Ladizinski. The briefing schedule was for him to file his brief on January 12th. The response was to be filed by Mr. Erdman on January 14th. The reply was then to be filed, if there was one, by Mr. Ladizinski on January 15th. And then an original hearing date of January 19th was scheduled. As you all are aware, on January 19th, the matter was recessed to today. Also on January 8th, board exhibits number 1 through 7 were all admitted into evidence. The board exhibits were, and I will just read them, were the in each case, each of these 9 cases were the objector's petition, the candidate's nomination papers, the call of the electoral board, the agenda for the initial hearing. I'm sorry, the objector's position was exhibit 1, the candidate's nomination papers were exhibit 2, the call of the electoral board for each hearing was exhibit 3, the agenda for the initial hearing was exhibit 4, the proofs of service, waiver of services, and appearances filed by the parties was in exhibit 5. The rules of procedure were exhibit 6, and when applicable at that time, exhibit 7 was the Circuit Court Special Order 2020-53, appointing electoral board member at that time, Daniel Kelly. I would ask first for the board to, again, collectively in these 9 cases, move to admit into evidence in each of these 9 cases, exhibits 1 through 6 inclusive. Would one of you members make, please, Miss
Just call me Judy, don't worry about it.
Judy, would you please make that motion?
I would make a motion to admit the exhibits 1 through 6 into evidence for the various boards.
Okay.
I'll
And
second.
can we get a second, please?
Second.
Mr. Kelly, thank you. Okay, roll call. Judy?
Yes.
Mr. Kelly?
Aye.
Mr. Johnson?
Aye.
Mr. Vargas?
Aye.
And Mr. Bertucci?
Aye.
Now, with respect, thank you very much. Those exhibits will be admitted as part of the record in 2020 BIMOEB-01 and then 2020 BIMOEB-03 through and inclusive to 2020 BIMOEB-10. Now, with respect to Exhibit 7, since the initial Circuit Court Special Order 2023 was admitted into evidence, that order pertained solely to public member Daniel Kelly. And that was with respect to 2020 BIMOEB-01, 02, and 03. At this point, there was a superseding order, special order, entered by Judge Sanjay Taylor on January 19th, 2021, as special order number 2021-20 revised. The subject was appointment of public member to Blue Island Electoral Board. I will not go through the reading of the entire order, but it appointed Judith Coleman, Daniel Kelly, and Robert Bertucci as public members to sit along with Domingo Vargas and Dexter Johnson on the boards hearing these matters. As well, Judge Sanjay Taylor also issued an order on January 15th, 2021 in case number 2021 COEL 000001, detailing the structure of the various electoral boards and the members who were qualified to sit or disqualified to sit on the various boards. I would ask for a motion to accept these two orders along with the original order that had been admitted into evidence, it's 2020-53, into evidence as a group exhibit 7 as part of the record in these proceedings. Would someone make that motion?
I would make a motion to admit group exhibit number 7, which consists of all the orders by the Circuit Court of Cook County Division.
Motion by member Coleman. Second, please, by member Kelly. Roll call, member Coleman,
Yes.
member Kelly,
Yes.
member Johnson. Member Johnson,
He's trying to log back in.
okay. Member Bertucci,
Yes.
member Vargas,
Aye.
and member Johnson, can you hear me? Member Johnson, are you with us there? Randy, is there some way if you can find out if Dexter can hear what we're doing?
I'm not there. He just got in the,
He can. He's back on.
Dexter, are you on?
Yes, sir. Unmute me. Can you guys hear me?
Dexter, we can barely hear you.
That's because you hear me off Steve's phone, but Randy needs to unmute me.
Randy needs to unmute him.
Randy, you have to unmute Dexter, I guess.
he's not muted.
Right. Hear him.
Dexter, are you on?
Yes, I am.
Is he at the city hall at the?
Yes,
He is.
He's with Steve, and I could hear the yes and the.
Maybe he needs to move from the proximity of Steve Ledizinski.
No,
We're
Reasons I
close
left.
to 100 feet apart.
In that room, kind of hard.
it has nothing to do with being by Steve. He's not on. I mean, he's on. He's not muted.
Okay, well, we have,
He can hear the proceedings, Carrie.
okay, but we cannot hear him.
Hold on. We'll share a phone.
Okay. Dexter, we just need to know if you're voting, if you'll vote with respect to the admission of Group Exhibit 7 into evidence.
Aye.
Thank you. Okay, we can then move along.
Oh, shit.
Board Exhibits 1 through 7 are all admitted into evidence in each of the 9 proceedings presently being heard in a consolidated manner.
Mr. Horvath?
Yes.
Can Board Member Johnson move to an office so that that he isn't going to get the same problem that we had when we appeared last time and agreed
We're on one
to
phone.
avoid this?
Can you hear me?
Yes, I can hear you, Steve.
We are using one phone, so there's no feedback.
Okay. That's fine, as long as when Dexter speaks, he just identifies himself, okay?
It says
Okay.
Dexter's phone's still on. It says talking permitted Dexter Johnson. So he'd need to hang up
No,
on
my
his
phone's
phone or you're
off.
gonna get that.
It's not on. He's got it off.
Okay.
Is,
Okay, and
is there
then
a
there,
reason that you can't just move to another office and not be in that room?
whatever works. I mean, we're trying to do this as efficiently as possible. If that works, as long as if Dexter has a comment to make or a vote to weigh in on, he just has to identify himself and that the fact is that he is speaking, so that we can move along. I don't know if there's a separate office or anything like that that is accessible to him at this point in time.
Okay, I just, the appearance of a board member sitting next to the attorney arguing before the board using the same phone is, I mean, there's no reason for that to be part of the hearing. And if he has his own phone and can move to another office there in the village hall, then
Is Dexter, is there a way to do that?
I'm going to try, Councilman. This is Dexter speaking, but we're over 100 feet apart when we're using the phone the last time.
So if I may, it has nothing to do with the proximity to each other. Dexter, if you could, there's 2 things you can do. You can either hang up and call back in, or you can call me on my cell and I can have you log in on my computer on the DS.
Okay, Randy. But the thing is, my phone is off. It's not even on.
Well, it is. I'll disconnect you and then you try and log back in.
Okay, if you
All
say
right,
so.
No, you're still connected. You're still connected, Dexter.
Okay, but I'm just letting you know my phone is off. I got it in my hand. Okay.
So turn your phone back on and call me on my cell and I'll get you logged in on the PC on my chip.
Yeah.
Yeah, call him on the cell.
Carrie, did we lose Robert Bertucci? I don't see him anymore.
Yes.
Sorry, Judy, could you say that again, please?
Did we lose Robert Bertucci?
It looks like we did.
He's
Back.
he's on. He's just muted at this point in time.
Okay, thank you.
Yeah, I'm down on the other end there.
There he is. I see.
Yeah, I know. It was your phone. So if you.
Okay.
So, okay, turn the computer on underneath.
Judy, do you see me on?
I do. Thank you.
Okay. Thanks. I switched devices.
Okay.
There are 2 rooms there. When I was with Dexter and Steve, there's the big boardroom and there's a room behind it. Because the 3 of us were in one room, I went into that back room. So if that's an issue, there is another heated room behind the boardroom. I don't know if that's an issue for them.
We'll just wait for Dexter to get back on because there's one more exhibit that needs to be admitted just with respect to board one or the board hearing 02.
He's trying to log in right now. Give him a minute.
Should we wait until we do that hearing since it doesn't pertain to the legal issue?
We can do that too, Judy.
Just to keep everything a little straight.
Okay, that's fine. I'll just hold off on that, okay?
I'm stepping away for 30 seconds. I'll be right back.
Okay.
Yeah, Carrie, procedurally too, should we just open up 01 and then make a motion to do the consolidated argument? Do you want
Yes.
Okay. It's gonna be time for lunch soon. Or breakfast.
Thank you.
This is Dexter.
Okay. Judy.
And this is why I drove there today instead of Zooming.
You know, I think we had made a decision the last time just to all Zoom. I mean, I would have come down if we weren't, but.
Jerry, I believe everyone is not connected.
Is everyone connected?
I am.
Okay. We have Judy, Domingo, Scott, Dan, Bob, Steve, and Dexter. Okay. All right. Well, Judy, you have a motion that you would like to make at this point in time?
At this point in time, if we could open up the first hearing, which would be 2020 BIMO EB01, and that would be Aliva, et cetera, versus Randy Hauser. And then after we open it up, I would like to just do a motion to proceed with the consolidated argument for the legal issues involving 01 and then 03 through 010.
That's the motion. Is there a second?
I'll
Mr.
second.
Kelly?
Yes.
Okay. On a roll call, Ms. Coleman,
Yes.
Mr. Kelly,
Yes.
Mr. Johnson,
Aye.
Mr. Bertucci,
Yes.
and Mr. Vargas.
Aye.
Okay. All right. So the first matter is a motion, a preliminary motion filed by Mr. Ladazinski, if I'm not mistaken. And that is a motion to strike the late response of the objectors to the motion to strike. Mr. Ladazinski, would you identify yourself and
Yes, Stephen
present the motion,
Ladazinski.
please?
This is Stephen Ladazinski on behalf of the candidates in the cases that are being argued on a consolidated basis. What we have here is a proceeding that is very expedited. If you take a look at the statute, the Electoral Board within 3 to 5 days is to move upon and act and hear objection proceedings. My clients are all candidates seeking their constitutional right to appear on the ballot to run for office here in the city of Blue Island. The January 8th status hearing was the initial call. This board entered a briefing schedule, and that briefing schedule was consistent across all cases. In fact, I attempted to discuss consolidating the cases at that time so I could file just one brief, and the objectors opposed that. So I've literally filed 9 motions to strike and dismiss the objectors' petition pursuant to the order and by the Electoral Board. Subsequent to the entry of that order, we appeared before Judge Taylor on a complaint filed by the objectors, and Judge Taylor entered an order on January 12th that the briefing schedule of the Electoral Board remains in effect. Once again, we appeared before Judge Taylor on January 15th, and he said, and I provide the transcript, it's page 38, that the Electoral Board's briefing schedule stays in place. Candidates timely filed their motion to strike and dismiss. The objectors were to file by January 14th at 11:59 p.m. This gives the objectors the opportunity to take full advantage of a day. Business day rules don't apply in the world of election cases. They filed no response. They finally filed a response on January 17th, days late, and it's beyond the time period in which I was to reply. They've not asked for leave from this Electoral Board to do a late filing, nor have they even currently asked in a written pleading that their late response be accepted. As I said before, these are expedited matters. And what we have here are objectors that have flaunted not only the order of this board, and it's a directive and rule, and I cited the rule, Rule 5, but also violated Judge Taylor's order that the briefing schedule would remain in effect. What we have here is the typical situation of objectors jerking around candidates. And I use the word jerking around is because certification is only days away. Early voting is less than 14 days away. How do we resolve an objector's petition when we have the objectors not following the briefing schedule of the Electoral Board and also the court? I want to point to the prejudice here. Is the prejudice my client's right? Likewise, there's a limited number of lawyers that do this type of work, and there's a lot of reasons why, because of the fast pace and the dedication and time. I had no time. When I entered the briefing schedule, I was building into a briefing schedule a time period in which I could provide a realistic reply. I was not afforded that opportunity, and what the objectors want to do is basically just argue that they should be allowed to go forward with their objection at this late point. The fundamental due process requires that this board not only disregard the late response, but to also dismiss the objector's petition for violation of the Electoral Board's rules and the order of Judge Taylor. Ruling upon this at this late date puts the candidates in a very bad procedural posture of seeking relief if there's an adverse ruling, to file a petition for judicial review, get a determination of that judicial review, and going up to the appellate court. There's no way conceivably to get all that done before voting starts. You need to take that into account when you balance the right of the objector to proceed. And what's important here is they not only have to proceed with their objection, they have to do it expeditiously and timely, and they have not. And for those reasons, we believe that the entire objector's petition and the late filed response should be stricken and the objector's petition be dismissed.
Mr. Erdman? Are you finished, Mr. Lezinski? I apologize.
I am.
Mr. Erdman?
The objectors filed their response to the motion to strike after hearing in the hearing before Judge Taylor that they had been filed. I spoke up immediately and said that I hadn't received them. They had been quarantined by a part of the email system. I responded the 2 days later. As to any prejudice that the candidates might have experienced, they were filed on the 17th. It's the 22nd. So they've had these response to the motion to strike since then. There's no prejudice. They're available. They're ready to argue them if they want to. As far as violating Judge Taylor's order wasn't that parties had to respond based on the briefing schedule. He just said that it wasn't stricken, which is, that's a red herring. The candidates themselves were part and parcel of the obstruction of our request to properly board in the first place, which has delayed this proceeding until now. And to cry about the delay after actively obstructing the proper constitution of the board for this long, it's just not genuine. The issues are before the board. There isn't any prejudice to the candidates to hear them now. And I would ask if all the board members have the motion to strike and the response.
Can I just ask one particular, on the or make one point? On the January 12th, 2021 order entered by Judge Taylor, he did indicate that the current briefing before the Electoral Board is to remain in effect. That was part of his order. And if I'm not mistaken, that was the order that you prepared on that date, correct, Mr. Erdman?
The order is immaterial.
Well, I'm just asking if that's correct.
I would have to check my notes, and I'm not prepared to answer now.
Right, well,
it's immaterial.
That order, members of the board, is in evidence, right? Or excuse me, is part of the public record, and I am reading from it at this point in time. And it's part of the public record in 2021, COEL 00001. And it states at point 6, the current briefing before the Electoral Board is to remain in effect. It's signed by Judge Sanjay T. Taylor and entered on January 12, 2021 by the clerk of the circuit court. And at the bottom is Mr. Erdman's name and address, indicating that he was the preparer of that order. Mr. Ladizinski, do you have any other remarks to make at this point in time in response?
I'd like to address your recitation of the order. The order was for a briefing schedule. There's briefing schedules in every electoral board proceeding. The fact that that schedule appeared in an order from Judge Taylor does not matter here. What we have is an issue came up with this briefing schedule. Because I didn't receive the motion to strike, and I'm not claiming that he did not send them. I'm just saying that that's how I received them late and brought it up immediately at Judge Taylor's hearing, and then filed my response. The board can, look at this and say, look, there was no prejudice to the candidate. He's had all of this time to sit with my response. He had all this time he could have filed a reply if he wanted to. And there's no prejudice. And again, I will ask if the board members have been provided with my filing.
Mr. Ladizinski, do you have any other comment?
Yeah, what Mr. Erdman is ignoring is the other cases that I was working on at the time. I provide that at page 9. But it is nice for Mr. Erdman to suggest that somehow this is my fault because he didn't comply with orders and my client should be prejudiced because he submits something late. This is a violation of the briefing schedule entered by the Electoral Board and the rules of the Electoral Board. The objectors show no shame in just saying, yeah, you need to accept it. It's filed late and, let's go forward. Just ignore the candidate's rights. I think it's really disingenuous. He did receive it. They were sent. There were orders entered by Judge Taylor. I really take offense when Mr. Erdman says that my clients were somehow involved in the delay. We intervened in less than 24 hours after Judge Taylor removed Mr. Stevo from serving on the board and was granted leave, and the court actually granted our motion to disqualify the handpicked, let's be honest, the handpicked judge that the objectors wanted, Nancy Rita. So we've moved along very, very timely in that case and also this case. And proceeding with an argument on his motion basically violates my client's due process rights. And the rules of this board, and each of these boards may have separate decisions, but you cannot ignore the fact that he's not even asked for leave to file the late filed response. And then somehow it's my fault that I need to, how would I say it? I'm supposed to file a reply because he did something late when I'm in the midst of one evidentiary hearing after another.
May I say something, Kerry, if the attorneys are done?
Just going to ask if any of the members of any of the respective boards have anything to comment. Certainly.
All right. So, obviously the better practice is to ask for leave, maybe call counsel on the other side. I know these are adversarial proceedings, but that doesn't mean we have to be confrontational or do things without phone calls or asking the board to file it late, asking Judge Taylor. I think we were all, the attorneys involved were aware of the schedule. That wasn't done, and that would have been the better practice. I think that's the professional thing to do, quite frankly, Mr. Erdman. That said, and I know Mr. Ladizinski is very busy, as many election lawyers are, so it's got to be, a bit overwhelming, and now you're getting things late, and you've got other things going on. But I would say, Mr. Ladizinski, you did spend a good amount of time objecting to the late filing. I mean, a lot of time was put into that memo objecting, and perhaps a little bit of time could have been put into responding to it if there would have been a response. I don't know that
If I may
think
address
we're
that,
done at
Judge?
point. So, you know, I just want to, you know, say that, and ultimately we're going to be, this is a matter of the notary, and the law is going to be what the law is. And I trust my fellow board members and I will analyze things and follow the law regardless of what anyone may argue it is, if they're wrong. So that's all I want to say, but certainly the better practice is to, you know, contact the other side, ask the board for another day or two, you know, not just let it go. And Judge Taylor did sign that order, purportedly drafted by, you know, Mr. Erdman. So that's all I wanted to say.
May I add something?
Judge, if I,
May
Judy?
may I add something? First of all, under Rule 5, I do not really see how we can just dismiss the case because there was a late filing. It really doesn't say. It also says you really don't have to file a written response. I note that the response is late. Whether or not we allow the written response, Mr. Erdman would still be able to orally respond to the motion to dismiss, and it's his right to cite any cases he wants to.
Right.
So I think this whole argument is basically irrelevant. I really don't think that the rules allow us to dismiss the case based on a late filing.
And I agree, we certainly should not dismiss the case.
That being said,
if I may address one issue, Mr. Judge Bertucci.
Yes.
I had to call an associate in the office to draft that.
I'm sorry.
It was done by Natalie Wilkins. The objection was drafted by Natalie Wilkins while I was in a 12-hour hearing.
Sure. I know. I appreciate that. I saw her name on there, and I trust you're overwhelmed. It has to be annoying, to say the least, when that happens. But I don't think dismissal is the answer. I agree with Judy.
with that being said, I think the arguments have been fully presented. Since Board 1 is hearing this, would a member, as well as the other boards are hearing the same argument, but I would first ask, would someone from Board 1, which includes 3 public members, would someone make a motion to either grant that motion or deny that motion? And then we would need a second. And then I would ask, after the members of Board 1 have voted, if the members of the other boards collectively would also vote, so that we can do it with respect to this motion. Since it's preliminary, I believe we can do it in a preliminary fashion. So first, Mrs. or Judy, would you make a motion to either grant or deny that the motion to strike the late filed response?
Okay, I would grant a motion to deny the motion to strike the late response, acknowledging the fact that it was late and that the board has the right to consider any other arguments that would be made on either side in regard to the motion to strike.
All right, so there is a motion to deny that preliminary motion. Is there a second?
I'll second.
Motion made by public member Judy Coleman, second by public member Daniel Kelly. With respect to the board on BIMOEB-01, roll call on that motion. Member Coleman.
Yes.
Member Kelly.
Yes.
Member Bertucci.
Yes.
Okay. The motion is denied. Now, with respect to Board 03, let me get my chart. I don't want.
I could tell you I'm not on it.
I'm not on, I can step away for now.
We would need a motion or a second to either grant or deny. It'd be actually with respect to board 03, the members are Chairman Vargas, Member Johnson, and Member Kelly. With respect to that board 03, is there a motion to either grant or deny the motion to strike the late filed response?
I'll make a motion to grant it.
Motion by Member Vargas to grant the late filed response. Is there a second?
Johnson.
Motion to grant the late filed response. Or motion to grant the motion to strike the late filed response made by Member Vargas, seconded by Member Johnson. Can we get a roll call on that motion? Member Vargas,
Aye.
Member Johnson,
Aye.
Member Kelly.
No.
The motion to grant the request, or the motion to grant the motion to strike the late filed response of the objectors is granted by a vote of 2 votes aye, 1 vote no, the no vote by Member Kelly, the aye votes by Members Vargas and Johnson. Now, on boards on BIMOEB 2020-04 through 2020-10 are Member Vargas as chairman, Member Johnson as a member, and Public Member Bertucci as a member. We can either go right down the line from 4, 5, 6, 7, 8, 9, 10, or we can make one motion in a consolidated manner with respect to the pending motion to strike the late filed response of the objectors. Is there a motion to either grant the motion to file the late filed response or deny the motion to file the late filed response in 2020 BIMOEB 2020 04 05 06 07 08 09 and 10.
Mr.
Horvath, Mr. Horvath,
Yes.
We agreed that the argument on the motions could be heard for all of the cases.
Okay, would you like to have a separate motion?
And I agreed to that.
Okay.
And now we have hop, skipped, and jumped into combining the procedural aspects of those cases to move ahead on this.
I apologize. I will then just take each one separately. I apologize, Mr. Hood.
And if you would like to address me and ask me about that, then we can move on.
Would you object to a consolidated motion on those 7 matters, or do you want a separate vote on each one?
On the single issue of whether to grant motion to strike my pleading without waiving my right to go ahead and argue it afterwards, I would be okay with that.
Okay, so I apologize. I should have asked you, and I please accept my apology.
Right,
Okay,
so I will also move to deny the motion to strike, allow the late filing with, you know, the sort of cautionary words I mentioned earlier, that there's a better way to do things, and but that said, that is my motion.
okay, Mr. Bertucci has made a motion to deny the motion to strike the late filed response of the objectors.
Correct.
Is there a second to Mr. Bertucci's motion? There being no second, the motion fails for lack of a second. Is there a motion to grant the motion to file the late filed response of the, or to grant the motion to strike the late filed response of the objectors to the candidate's motion to strike?
May I ask, I know I'm not on these boards, but may I ask a question here?
Certainly.
The filing is called a motion to strike and dismiss objector's petition. I mean, are you bifurcating it and just doing a motion to strike rather than dismiss?
In terms of the motion, well, Carrie may want to answer that, but my motion would include both, and I'm glad you clarified that.
I'm clarifying it too, because for, what was it, for 3? It wasn't clear whether they were granting both parts of the motion.
Are you referring to the motion that Mr. Ladizinski presented to strike?
It says a motion to strike and dismiss.
Okay,
Okay, so
yes,
board 1 denied that motion.
yes.
Board 3 granted it, but is it granting both the motion to strike and to dismiss? It wasn't.
Okay, well,
Good point.
We'll go back to board 3, but right now we're on boards 4 through 10, and thank you very much for clarifying that, Judy. Okay, so presently before you is the candidate's motion to strike and dismiss the objector's late filed response to the candidate's motion to strike and dismiss the petition. So is there a motion present to be made granting that motion?
I'll make the motion.
The motion by Member Vargas. Is there a second?
Johnson.
Second by Member Johnson. Does anybody have any other comments to make with respect to that motion? Okay.
I'll say this, I'd be sympathetic to striking, but not dismissing the whole case as a result of that late filing. That doesn't go to the issue of, but anyway.
This is not dismissing this is not dismissing the whole case. This is just striking his written response. He will still be permitted to argue his position, from what I understand. I mean, so, but we have that motion pending. And let's do a roll call. Member Vargas?
Aye.
Member Johnson?
Aye.
Member Bertucci?
No.
That motion is then carried, and in cases 2020 BIMOEB 04, 05, 06, 07, 08, 09, and 10, excuse me, the late filed response to the candidate's motion to strike and dismiss is stricken. Now, so that we have what I would hope would be a clear record, excuse me, on 2020 BIMOEB 03. There was a motion to grant the candidate's objection to the objector's late motion to strike the objector's late filed response to the candidate's motion to strike and dismiss. Member Vargas, you made a motion to grant that motion to strike. Is that correct?
That is correct.
And Member Johnson, you made a second to that motion. Is that correct?
Okay.
And then Member Kelly, you voted no to that motion. Is that correct? Member Kelly, you're muted.
You're muted.
Yes, I voted no on case 3.
Okay. So with respect, we'll remake that motion then to grant the motion to strike the objector's late filed response to the candidate's motion to strike and dismiss. Would you make that motion again, Mr. Vargas?
Yes, I make that motion that you just relayed to the board.
Is there a second?
Johnson.
Roll call. Mr. Vargas,
Aye.
Mr. Kelly,
No.
Mr. Johnson.
Aye.
Okay, so the candidate's written response, or excuse me, the objector's written response to the candidate's motion to strike and dismiss the objection is stricken in cases 2020 BIMOEB 03, 04, 05, 06, 07, 08, 09, and 10. In case number 2020 BIMOEB -01, the written response to the candidate's motion to strike and dismiss remains in effect. With respect to the motion to strike and dismiss, in those cases in which the written response, was stricken, the candidate will still have an opportunity to make an oral response to the motion. I think I've stated it as carefully as I can with respect to all of those motions. Does anyone have any either criticism of what I've stated because it was incorrect, or that you think should be added to what I just put into the record?
I think you meant to say the objector will be able to argue, not the candidate.
Oh, I'm sorry. Did I say I'm sorry. I meant the objector. Yes, yes.
This is Steve Ledezinski. My objection also asked for dismissal of the objector's petition, and there was no motion or action on those.
Exactly.
Yeah, that's what I was trying to point out.
The written response was stricken, but it's my advice to this board that in fairness to the objector, that they still should be allowed, the objector should still be allowed to put forth a written, or an oral argument in response to the motion, even though the written objections, the written briefs have been stricken in some of the matters pending. And so that's my advice to the various boards. I think the board in 01, they don't need to follow that advice because they denied the motion, but the boards in 03, 04, 05, 06, 07, 08, 09, and 10, I think should follow that advice. And we should get on now with the motion to strike and dismiss the objection. If that's my advice to the boards, unless there's some sort of an argument to the contrary, that's, I think, the way we're going to proceed. Okay, then would the board mind if we took like a 5-minute break? We can just all take catch our breath, figure out where we're at, and then get back to this. Is that acceptable?
That's fine.
That's
Could
fine.
we do 10, please?
It's 11:53 right now. How about coming back and pardon? Noon?
Whatever you choose.
We'll take a recess then and make a motion to recess until noon.
I'll make the motion.
Second.
We can, I think, do just a voice vote on that. All in favor?
Aye.
We'll be back at noon.
All right. Thank you. There you go.
Judy, I have a mental block with respect to your last name. I keep wanting to call you Kidman. It's like, I don't know.
I wish I had her money. The good thing, you wouldn't want me to use my married name because that would even be worse. Coleman's my maiden name. But I'm fine with people calling me Judy. I'm pretty informal.
As my father used to say, call me anything, but please don't call me late for dinner. He used to-
I'm sorry I interrupted you. I just thought that was
No, I think it was appropriate. It was a good point.
see, Robert changed.
Oh, hi.
You
Still
changed your
driving.
outfit.
I did that while I was driving, by the way.
Hey, we have everybody. We have Judy, Bob, Dan, Scott, Domingo, Steve, and Dexter. Is everybody on?
Yes.
Yes. Dan is on mute. Kelly.
Yes, I am. I'm here.
Hi, Dan. Hey, Dan.
All right. The next order of business then will be the motion of the candidates strike and dismiss the objection to the objections filed in cases BIMOEB 2020 BIMOEB 01, 03, 04, 05, 06, 07, 08, 09, and 10. Is there any objection by either the candidate's attorney or the objector's attorney to consolidating the oral arguments on this particular motion? Mr. Ladizinski?
I have no objection.
Mr. Erdman.
I have no objection.
Will one of the members please make a motion and to consolidate the arguments, oral arguments, and the motion to strike and dismiss the objections to the candidates' petitions in the 9 cases I have identified.
I would make a motion to consolidate the legal argument as to the notary in the cases 01 and then 03 through 010.
Yes.
And this
Second
is-
to that motion? Is there a- Mr. Kelly, a second?
Yes.
And Mr. Bertucci? Okay, let's do a roll call. Ms. Coleman?
Yes.
Mr. Bertucci?
Yes.
Mr. Kelly?
Yes.
Mr. Vargas?
Aye.
Mr. Johnson?
Yes.
Okay. Mr. Ladazinski, this is your motion. Would you like to present oral argument?
Okay.
Okay.
Yes, the paragraphs are different in.
I'm sorry, who was speaking?
Can you hear me?
Yes, now I can hear you, yes.
The candidates have a basic, fundamental, and substantial right to run for office. Well, it's not a guarantee. The objectors have raised a objection based on notarization, and in particular, that one of the candidates, Randy Hauser, notarized circulator affidavits appearing at the bottom of petition sheets. The objectors cite to Johnson versus Ames for this global overreaching approach that the Notary Public Act says Canada can't do that. Except Johnson versus Ames deals with a referendum out of Broadview and does not discuss the prohibition of an individual notary who may be a candidate for office notarizing a circulator's affidavit. They make this quantum leap in the objector's petition that since this is an Illinois Supreme Court decision and the word instrument is used, therefore the Notary Act prohibits this from occurring. They don't allege that there was impropriety on behalf of Randy Hauser with their transaction, that Mr. Hauser could not ignore the fact that there are more than enough signatures, presumptively valid signatures, that they do not challenge on any of these petitions. And they have to ignore decisions from electoral boards and circuit courts that have done the analysis. And I apologize for the length of the submission, but I did attach all of the available decisions from electoral boards discussing the process. And those boards have held that it was okay for the notary, who was also a candidate, to notarize the petition sheets, talking about notarizing the signature. And they make a delineation of why that exists. And I attached the law review article. I don't think it was a law review article, but it was an article by Professor Michael Clausen and another professor that talked about what notary publics can do and wives are allowed to notarize husbands' documents and vice versa, and relatives are allowed to do it. And there was no prohibition in Illinois law, even under the Notary Act, that someone that may have an interest in a document cannot notarize the document. And the courts have held that while a mortgage has to be properly notarized, and the individual that is the signer of the document cannot notarize it, which is not the case here. They're not claiming that Randy Hauser notarized his own signature. What they're claiming is that it's a prohibited transaction, and they want to ignore the body of case law from electoral boards. And it starts actually earlier than Jordan versus Lacey, which is 11 COEB J14.
Excuse me.
Steve, hold on one
it
second.
actually goes
Steve?
back to the 90s of
Steve?
elections and
Steve,
other.
Can you hold on 1 second? The court reporter needs to change her paper, if I'm not mistaken.
No, I
Okay.
don't need to change my paper. But was anybody else getting a reverberation when he
Yes.
was?
Yes.
Okay,
Yes.
so it's just not my internet. Okay, so I just need you to go back to where you started to cite the case. Prohibited action and ignore the body of case law from electoral boards.
From electoral boards, including the Chicago Board of Elections and other municipal officers' electoral boards. These decisions have analyzed that what the notary is doing is the transaction is watching an individual sign their signature in front of them and then placing their signature and their notary seal on the document. And SCIMO, SCIMO versus Miania, MAINA, 96 EBWC 43. That's a water commissioner case. And Hill versus Municipal Officers Electoral Board, which was a Cook County case. Both found that there's nowhere in the election code that says you must invalidate candidates' petitions solely because the petitions were notarized by the candidate. In fact, in Gibson versus Sharp, 91 EB ALD 77, a candidate may notarize signatures other than his own signature on the candidate's petition sheets. So
Steve?
Law has treated
No, you have to stop.
rights to, yes.
Okay.
Hello.
Yes, start again after you cut out again. The candidate may notarize signatures other than his own signature on the candidate's petition sheets. And then you were starting a new sentence. Is anybody hearing anything?
No.
Okay.
No, we're having problems.
Okay. Are you able to hear me now?
Steve? We're getting the same thing. Are you still in
I'm
control?
totally.
If he's in the East Annex, that thing is built
Can
like
you
a
hear me?
fortress.
Hello? Hello?
Steve, we hear you.
Okay. So Illinois law has carved out and has actually expressly stated that candidates are able to notarize petition sheets as long as it's not their signature. This whole creative argument raised by the objector and stringing together a bunch of cases ignore the Electoral Board decisions. And Johnson, if you read Johnson versus Ames, There's nowhere in there or any case that they cite that says in Illinois law, and they cite general boilerplate that, you know, everything must be notarized in the election process, and that it's important. And Johnson versus Ames says it's an instrument. Nowhere can they cite a single decision that says a candidate who's a notary cannot notarize petition sheets of other individuals. For that reason, this objection has no legal basis and must be dismissed.
May I ask you a question
Sure.
of Mr. Lazinski?
Yes.
Is in the petitions in question that Mr. Hauser notarized, is he a party to that petition?
What do you mean a party to that petition?
Well, I mean, a party to a contract would include the buyer, would include the seller, the real estate transaction, for example. You referred to this petition as an instrument because Ames versus Johnson did, but they also used the word party. And that's why I'm asking you if Mr. Hauser's a party to this petition being named as a candidate.
The decisions from the Electoral Board discuss that, and they indicate, and they would expressly held that he's not a party to the transaction. The decisions from the Electoral Board discuss that, and they indicate, and they would expressly held
I can't hear you.
okay, that he's not a party to the transaction.
Mr. Ladizinski, there's some reverberation, and were you able to, Mrs. Nagel, were you able to hear what he said?
The last thing I have is him answering, the decisions from the electoral boards discuss that, and they indicate they expressly held that he's not a party to the transaction.
I had gotten reverberation here. That's why I was asking.
Yes, sir.
Okay.
I asked because and I did read everything you submitted. It was significant. But, obviously very important, read it all, but they were electoral board decisions predating Johnson Ames. Johnson was not a candidate situation. It was a referendum, but they do talk about in that case, and it's an appellate court opinion from 2016, again, subsequent to the electoral board rulings you cited. They talk about that document, the petition, being an instrument, and you agree with that.
I did not agree with that.
Oh, you did not? Okay.
I did not agree with that. That's what the objectors are trying to state.
Okay, that's fine. I thought you felt that you disagree that Hauser's a party, but that the petition is an instrument. Okay, that's fine. You say both are not the case. Not an instrument, and he's not a party. The appellate court, though, in that case, Johnson v. Ames, did say that a petition is an instrument. Again, in their case, it was a referendum, not a candidate case, that it was an instrument. And they also said that notary, whose notarization was in question in that case, did not appear as a party anywhere in that instrument. So they called it an instrument. And I'm asking if you consider your client a party, the appellate court, it seems to me in that case, is taking the view that a candidate is a party in a petition. They call the petition an instrument, and they said the notary's name does not appear anywhere in there as a party. Because again, it was a referendum. You don't think they were perhaps referring to, doesn't appear in there as a party, but if they were a candidate, they would have been in there as a party, triggering the statute, and then resulting in the same thing that occurred would have occurred in Colorado in that case, where they made a distinction between
and the Colorado.
Go on.
Well, we're talking about Illinois law, and with regard to Illinois and the Electoral Board, the circuit have followed the law where they've carved out this exception. And I'll say it's a carve out from the standpoint of they're looking at what's occurring and what is going on. So he's not a party to the transaction, and the transaction is just acknowledging or witnessing the signature.
I see. He'd be a party, you're saying, if he was one of the signers.
Correct.
I follow you. Okay.
I have a question to Mr. Ladazinski. In your article that you attached to your motion,
Yes.
on page, on page 5 of 12, it states that the Illinois notary law does not even prohibit notaries from notarizing documents in which they have financial interest unless notaries are named therein. Are you interpreting that in this case that the candidate wasn't named therein?
Yes.
Why so?
Well, the position of the objection is that the candidate Hauser could not notarize any petition at all. Okay, and they're you know, from my perspective of the case law in the election arena and the election law, is that notaries that may be a candidate are not prohibited from notarizing the signatures at the bottom of the petition sheets.
And as far as you know, there's no appellate court case
That's
on
correct.
this issue.
That is correct.
All right, because, okay, a lot of these cases are fairly old that you attach, correct?
They're fairly old, but there's decisions. I'll give you a decision from 2012. I can't remember. I think it's Reeves versus Gamboni. This same issue came out, and once again, the Cook County Electoral Board accepted this case law as current. And I believe 2 years ago, I had another case before the Cook County Officers Electoral Board, and they've accepted this case law.
So you didn't include any of those cases in your response, correct?
I did not, because they were just simply decisions. You know, they were not, there was not the analysis of it. It just said basically citing these cases.
Okay. Thank you.
Any other, excuse me, any other questions from members of the board? Mr. Ladazinski, do you have any other comments?
No.
Mr. Erdman?
Thank you, members of the board. The argument flows, or objection flows quite simply. It goes through the election code where notarization is required under 10.4. It goes through the Notary Act 6-104B about notarizing instruments that you're a party to. and then lands squarely within Johnson v. Ames, which states that the petition is an instrument. That's the key language from Johnson v. Ames that controls all of this. So it's not about the number of signatures that are involved. Mr. Ledzinski says that we should ignore electoral boards and circuit courts. Well, that's what we do when we get an appellate decision that specifically speaks to the issue. As far as what notaries can do, articles from scholars don't decide the issue. The courts do. The example of a mortgage instrument is, notaries can't notarize. They can't go to a real estate closing and buy a house and notarize all of the documents in the closing. There's a reason for that. So, we move to his argument that nowhere in the election code is this prohibited. Well, it's not. But you have to read the election code with the Notary Act. There's no getting around that. They have to be read together. So you read those together, and instruments are discussed in the Notary Act. And then you look to Ames, and Ames tells us what an instrument is. And a nominating petition is an instrument. Okay? Then we go back to the petitions, the aggregate petitions, nominating papers that he's a party to. And then he notarizes an instrument that he's a party to, and that nullifies his notarial act there. It's not any more complicated than that. I think Judge Bertucci's questions highlighted this, and as did Board Member Coleman's questions. That's where we're at. It's not any more complicated than that. We don't need a plethora of board decisions from prior to Johnson v. Ames. We don't need circuit court decisions from prior to Johnson v. Ames. We need the election code. We need the Illinois Notary Act, and we need the Johnson v. Ames that tells us everything we need to know here. We have an interested party, we have an instrument, and we have a statutory declaration that they can't notarize that instrument. So it's not that complicated. Thank you.
Thank you.
Carrie, can I make a statement?
If
Mr. Ledzinski, do you have any other comment?
I believe there's someone else that wanted to make a statement.
I would like to, if it's okay, Carrie.
No.
Mr. Hauser.
Yes.
I'll ask the members of the board if they want to allow that. Mr. Hauser is represented by Mr. Ledzinski. He would like to make a comment. I don't know. I would.
Mr. Hauser will not be making this. Mr. Hauser will not be making a statement.
Okay. All right.
The one issue that I do have a problem with, and I don't know if either of them can.
You don't know if what?
To speak to it, is that all the cases presented by the candidate were prior to the Johnson v. Ames case. And there's and I'm not sure whether that changes the result or not. I'm a little troubled by the fact that in the Ames case that they say, I mean, the notary did not appear in the petition. It seems that they're saying that the instrument in question was the petition which the voters signed, and the notary's name did not appear as a party anywhere on that instrument. Does that mean that because Mr. Hauser's name appeared on, it is clear he did appear on the instrument, does that make him a relevant party to the fact that he can't sign the notary? And I don't know if anybody, notarized that. I don't know if anybody can answer that, because
Oh, we will.
I know that. I'm wondering if the parties that.
That's why we're getting paid the big buck.
And I know it might not be here. But that's what troubles me is that this case came after all the cases that were cited by the candidate, and those cases were from electoral boards, and they weren't appealed in the appellate court, so, or the circuit court, as far as I can tell. So, I mean, there's really,
I think one of the problems with
those cases are not dispositive to our decision.
Okay. I have a question
for boards.
For Ms. Coleman.
Yeah.
Are you reading Johnson versus Ames, the appellate or the Supreme Court decision?
I have the appellate court decision. Oh, wait. Yeah, I have the appellate court decision in front of me. Is there an
You need to read the Supreme Court decision.
Okay, what does the Supreme Court decision say? Was it reversed?
The Supreme Court, Mrs. Coleman, the Supreme Court decision really didn't address this. One of the problems with the appellate court decision was it came at the end because they were quoting both parties from their brief, and it was dealing with a referendum issue. It was not dealing squarely with a candidate's petition in an electoral matter such as ours. It was factually distinct. And I think in this particular, what the electoral boards have been saying for quite some time, even recently, is what the notary is doing is verifying the affidavit that's signed by the circulator. And that's actually the affidavit is the actual instrument that the notary is dealing with, if you want to call it an instrument. So they haven't squarely addressed, the appellate court has never squarely addressed the issue of a candidate's petition. And it only looked very, very briefly at the issue as it was raised in the appellate decision in Johnson versus Ames.
Okay, so
when it went up to the Supreme Court focused on whether the actual referendum question that had been presented was the type of referendum question that should be allowed to remain on the ballot. And it didn't really go to the question of what is an instrument, what is whether a notary is a notary is a party, or what is a party to that instrument. They really didn't talk about that at all, because they were looking directly at the referendum question. That was the Supreme Court case. And so,
well, yet Mr. Ledezinski says we really need to look at the Illinois Supreme Court case. And frankly, I didn't. But why do we need to look at it then, Mr. Ledezinski, if it's not addressing the notary question?
The notary question in the appellate decision it's a throwaway.
I understand. I know.
And
but
the objectors are
case?
making it seem like it's a holding, and it's not a holding.
I follow. But
so it's
what
great.
About the Supreme Court case, though? We don't really need to look at it, do we?
The Supreme, if it was an issue with regard to the Supreme Court decision, what I'm pointing to is they try to. There's some language in their objection. The Supreme Court has spoken, and they cite to Johnson versus Ames, and it doesn't even discuss the notary issue in the Supreme Court decision. And the appellate decision, it's dicta. So what they're doing is they're cherry picking, and they're ignoring the other case law, which is the Electoral Board law that's out there. And they say the instrument and the transaction is the bottom of the affidavit. We're not going any further.
Okay, so nobody appealed the decision in the appellate court in regard to the notary. The second question is, what I'm hearing is the nomination petitions are basically an instrument within an instrument. So the petition is one thing,
Correct.
and then the affidavit, you bifurcate it so that the affidavit becomes another instrument. Is that what you're arguing?
Seems to be what the analysis of the electoral board decisions is.
Sure. The electoral boards perhaps do that. They're calling the affidavit section the instrument that we're concerned about. And I understand that Ames versus Johnson or Johnson v. Ames, it's dicta, but they are calling the petition an instrument, and they're saying this was a referendum, and so this person who's being challenged for notarizing it, because they have an interest, they're favoring their proponents of the referendum, apparently, they're not a party. Indicating somebody can be a party to a petition. And who is a party to a petition in an election case that they're calling an instrument? Seems to me there's one party, or several if it's a slate, and that's the candidate or candidates. And so while I appreciate the dicta, and while I appreciate the earlier cases taking your side, it seems to me the appellate court in this case is telling us what they would have done if the case in front of them was a nominating petition as we have here. Granted, it's dicta, but how do we disregard dicta that to me seems to call and I'm sympathetic to candidates, believe me, and the ability to run and voters having a right to choose. But how do we disregard dicta I'm thinking of the code.
You started it, and now we're all going to do it. So go ahead and say.
How do we disregard that when it's calling the petition an instrument, and it seems to refer to a party, which they don't have in that case, a candidate? And so, and that's why I went back and read everything carefully. And so my view is, and I know we haven't heard from everybody, is that those cases do precede the 2016 opinion in Johnson v. Ames. The Supreme Court didn't address the notary question any further in Ames, so we have the appellate opinion with this dicta that I think guides us and tells us what they'll do if they get our case, it seems to me. And so that's my analysis of things.
So can I throw a curveball at you, Judge?
Absolutely.
The curveball is this: that every petition signer is a party to the transaction. Anyone that touches the petition based on this analysis is the party to the transaction. So if you think about it, we could play mischief. It's one thing to make the allegation that the notary did something wrong, like there's the false notarization or something like that.
Sure.
But what we have here now is a game that's being played by stringing together some decisions. And maybe this is the case that goes up. And you say, like, listen, we are going to disregard the candidate's rights. We're going to allow the objector to make their arguments, even though they didn't follow directives of the board and all these other issues. And we're going to say, is like, listen, we think that a candidate is a party of the transaction. And we also think that the notary, because here's the next slope, and this is where Clausen's article comes in. And I included Clausen's article because it's cited in one of the electoral board decisions, is the next step is, oh my God, the notary happens to be related to one of the candidates.
Right, that was a spouse.
Right. So that's the slippery slope you're going to be opening up in the arena here. So what's dead set in front of you is that Johnson doesn't stand for what the objectors are offering it for. It doesn't. There's not a holding. There's some discussion in there, but they're saying it's a holding.
Judge Bertucci,
Actually,
if I, go ahead.
there's been one side for quite a while now. I'd like to speak.
Go ahead, Mr. Erdman. I just.
Okay. You know, there's the argument that he's not a party. He's obviously a party. He's a candidate. There's the argument that the notarization of the circulator's jurat is somehow a sub-instrument that exists on a page with the rest of the petition, which the Ames court states. It's the instrument. The petition is the instrument. They're not ambiguous about it. They don't preface it with any kind of warning language or anything else. They just state finally that the petition is an instrument to provide clarity, where before all of these board decisions that the candidate wants to reference, you know, we're relying on the fact that it wasn't. Well, now we have the appellate court saying it's an instrument. Treat it as such.
If I may now, you're saying that they said the petition is the instrument.
Can I finish, please?
If I may.
Can I finish, please?
Hold on.
Mr. Erdman.
Mr. Erdman, if I may, I think you're
Just on that point.
misrepresenting a little bit of what the appellate court said. And they were comparing the petition to the affidavit in question. The affidavit in question was notarized by the proponent of the referendum. And so they were, and they said that person's signature was not on that petition. So, I mean, I think you're taking Ames versus Johnson versus Ames a little farther than what's included in the last section of that decision. But I just want to point that out to the board. Before I continue to have to argue against counsel, I'm not arguing against you. I just don't think it's fair to the board to.
We have.
You know, okay. Can I interrupt?
Can I please finish talking? I've sat here and listened politely.
Okay. Well,
can I finish talking?
Oh, Steve, let Mr. Erdman speak, please. Let him speak.
Okay.
Okay. We have attorneys sitting on the board. They know how to read case law. They've asked pertinent questions about the case law. It's before that. We've made our case. We're not, you know, council wants to talk about rights. Well, candidates also have obligations. They have obligations to follow the election code. Okay. You know, the argument of whether the jurat at the bottom is an instrument is, I mean, no, it's an instrument. The court says it's an instrument. Appellate court decisions, you know, don't take precedent over electoral board decisions. They take precedent over circuit court decisions. They take precedent over scholarly articles. We're not talking about a slippery slope. We're standing on flat ground where the appellate court says very clearly, the instrument is the petition the voters signed, period. And that's what we apply. And if you walk through the simple steps, we arrive at what the objection claims is what we're looking at here. So, you know, I appreciate being able to finish saying what I was saying.
I'd like to raise a question for the objectors counsel, Mr. Erdman, regarding this case. And I'm very familiar with the previous electoral board decisions. In the case of Hill versus Municipal Officers Electoral Board, which was decided in the county division by former Judge Curtis Heaston. And his analysis is that the penalties in the Notary Act don't extend to invalidating a petition, and a candidate may notarize a petition. And my problem, I've read Johnson versus Ames, and I read it at the appellate court opinion, and the argument is that it's dicta. And then the Supreme Court decision, which I read, didn't help very much because they narrowed their focus as to the referendum question being ambiguous or not, and they didn't address the others. But you're asking us to take a appellate court decision dealing with a referendum which is Article 28 of the Election Code. And these are nominating petitions for candidates under Article 10. How do you, get these to dovetail together? I'm at C here, and you've got like 29 years of Electoral Board decisions and Circuit Court decisions saying a candidate can notarize a petition provided he's not a signatory. And when a candidate or a notary had signed the petition, the maximum penalty, I recall, was to strike a single signature, and you're asking for entire pages to be thrown out. Could you address some of these concerns?
Yes, the terms used throughout the election code have definitions, and a petition is a petition, whether it's a petition for referenda, whether it's a petition for a new party, whether it's a petition for a candidate. A petition is a petition. And the reference to the fact that the instrument is the petition the voter signed in the appellate case, it goes right along with the mention of a candidate. It's not far afield. It's not plucked, individually, just a couple of words. It's what they're discussing. The penalties of the Notary Act don't apply here because the election code has their own penalties. There's the requirement that these be properly notarized. And all of the arguments prior to Johnson v. Ames treated the nomination petitions in one way, and Ames, the appellate court, tells us this is what it is. This is how you treat it. This is the definition of that piece of paper. It is an instrument. Then you take that back to the election code, and read in conjunction with the Notary Act, it tells us what to do.
And I appreciate what Mr. Kelly just raised, because I thought about that as well. Hey, there are other consequences, if you notarize something in an improper way, but it's not exclusive, is what Mr. Erdman is saying. And so that's, my view of that, that there are other remedies, for false swearing or, a notary doing bad things, but that doesn't mean it's the only remedy. If something is called for to be done under the election code and it's not, that's all I wanted to say.
I would just like to, I think cases in the election code, I know all of us use cases that are cited in one section of the election code to other cases, the other sections of the election code. I am noting though, Hill versus Municipal Officers Electoral Board. And I think, in my opinion, I think it is one instrument. I don't think it's two instruments. And I think that's the way Hill versus Municipal Officers Electoral Board viewed it. But what they said in that case is that they're stating that in the Notary Act, that no place in the Notary Act does the act say that any instrument acknowledged by a notary is invalid where the notary has committed an act prohibited under the act. And it does say the Notary Act provides remedies for official misconduct of the notary. However, there is no place in the election code that provides for invalidating a candidate's petition because the circulator's petition was notarized by the candidate on those petitions. So I mean, I do agree it's one. I don't agree that it's bifurcated, but I don't think the election code necessarily has a remedy for a candidate notarizing a petition that doesn't have his signature on it. In other words, he wasn't the circulator. He didn't sign that particular sheet.
And you raised something. It says shall here. It shall be notarized. But as we all know, shall means apparently something different in election law. It only really means shall when there's a consequence for not doing it. And election code doesn't call for the consequence you're asking for, Mr. Erdman. And that's another matter. I don't know if you have any thoughts on that, Mr. Kelly, fellow board member,
I was
or
wondering
anyone.
about this
If I can.
in terms of another major notary case affecting election matters, which was from Stevenson County, Illinois, the Shipley case. And there they had some people who appeared before a notary, did their work on the affidavits. Turns out the notary had failed to renew their commission and his commission had expired. And the court said the importance is the person appearing to sign the circulator's affidavit believes that they're before a notary and they're making an oath under penalty of perjury. And we've had this rule where notary misconduct or notary error doesn't go against the otherwise valid petition. I mean, I remember like the maximum is if a notary had signed a petition that they notarized, we used to strike a single signature. And the hardship here is they're looking to throw out an entire petition or bring a person below their legal minimum number of signatures. And I'm just having a hard time squaring this argument with the case law.
I appreciate that, but we would strike a ball if the notary stamped it but didn't sign their name. Right? I mean, there are things that would cause us to strike all of them, not only when, you know, the notary signed and as a the petition and then also signed as a notary. There are things that the notary could do or fail to do that would cause us to knock out a whole petition sheet.
But there also have been cases, and I think if you go through the Chicago Board of Elections decisions, cases where, and I can't remember whether it was the notary stamped it and didn't sign it, or they signed it and didn't stamp it, and you know the board held that that's fine.
Actually, there's an appellate case to that effect. It was called Agrella versus the Village of Kildare Electoral Board, 372 Illap 3rd, 1100, and it was a Rule 23 decision, but it was second district in 2007. And the court validated nomination papers containing 2 sheets that did not bear the signature and seal of the notary public. And what they said, what the court affirmed the ruling that the candidate's actions show more than substantial compliance. It held that although, in this instance, the notary's name was Lorino, although Lorino's stamp and signature are missing, that does not change the fact that Welch's statement was sworn to before some officer authorized to administer oaths. And I mean, I just happen to be looking through the continuing legal education, the most recent updated continuing legal education manual or book on election law, but that just to address what Your Honor just mentioned.
If I may, that's the issue of whether the circulator properly swore what he's alleged, what they're attesting to.
I was just answering Judge Tucci's.
I understand that. Now I'm addressing it. So that portion of the jurat is in that case law focuses on whether the attestation in the jurat is valid. This is a different question.
I didn't say it wasn't. I just was answering the judge's question.
Please, counsel, I haven't interrupted anyone here through this entire hearing. If I may, it's 2 separate questions. There's 2 different questions as to the validity of a sheet before an electoral board. And in that cases, the case law, the board decisions, that they address that issue. That's not the issue here. The issue here is whether these instruments, as defined as stated in Johnson v. Ames, can be notarized by somebody who's a party to the instrument, and he's clearly a party. He notarized them, and they're an instrument that he cannot notarize. He cannot properly notarize an instrument that he's a party to.
See, this is the rub, and this is where I'm having difficulty with this. The act of the notary is supposed to ensure there's been compliance on the part of the circulation of the pages by the petition circulator who completes the affidavit. And, there's been no argument that I can see that there was fraud in the circulation. So you're striking pages because the notary engaged in misconduct? Or seeking to, I mean, I'm sorry.
And counsel touched on the fact that there's no allegations of fraud. That's not the point. We don't have to make an allegation of fraud to point out that under the election code, the Illinois Notary Act, and Johnson v. Ames, what was done here is prohibited. And until somebody makes an objection on something like this, there's no ruling. We want, counsel and for the party and counsel for the board wants us to go look back at electoral board cases, and those are there because somebody raised the issue. We've raised this issue. We've pointed to the statute, the electoral code, the election code, and the Illinois Statutory Act, and the Johnson v. Ames decision. If we want to say that questions of first impression can't ever be heard because there's case law about this that precedes it, then we're going nowhere. But this is our objection. We've stated the law, both the election code and the Notary Act, and when we apply the facts of the petition being an instrument that Johnson v. Ames tells us to do, that's where we land. We don't have to allege fraud.
May I ask Mr. Erdman and Mr. Ladzinski a question? What about the fact that there's no consequence listed in the election code for this shall possibly being violated? In other words, can we find that you should not have notarized this because you are a party to this instrument? Certainly Ames calls the petition an instrument, but again, it's dicta in any event. But what about that fact that there's no consequence listed in the election code for what we do when we have a problem with the notary? Mr. Kelly raised the fact that fellow board member that that's quite a step to knock out entire petitions. Well, if it's appropriate, it's appropriate, but it is a significant step, and it's not specifically called for. There's not a consequence put in the election code, and it's, again, the one code that apparently shall doesn't always mean shall. So I just want to address that part to both attorneys, Erdman and Ladzinski, because that's where my concern now lies in voting today on this, being sympathetic to your reading, Mr. Erdman, of the dicta, which can be very important, and it is, in Ames. So what about that? No consequences listed in the election code. And other times when that's happened, the appellate court said shall doesn't quite mean shall. Doesn't quite mean must.
If Mr. Ladzinski wants to speak first, it's his motion.
No, he used your name first, Mr. Erdman.
Okay. All right.
Only alphabetically. That's the only reason.
Okay. Yeah, shall does appear all over the election code, and more often than some of us think that it should be, it's ignored. But that doesn't mean it's always ignored. And until someone gives us a reason why shall should be ignored, it's there. Shall. You shall do it. Period. And the obvious penalty for when somebody says you shall do this is that if you don't, then whatever you were supposed to do, obviously, it's negated. A candidate, is supposed to file a statement of candidacy that's signed and notarized. If they don't, they're not a candidate. There's the election cases before electoral boards and before circuit courts that all deal with that. that haven't been addressed in appellate court, like Ames just did with this question, they address that all the time. They address the conflict between shall and a specific penalty, and they invoke penalties. They apply penalties to failure to comply with a portion of the election code that says shall. And because they choose not to sometimes, doesn't mean that there's no consequence to the actions of the candidate here as a notary and under the code, the Notary Act, and Ames.
This is Steve Ladizinski. I want to discuss two things, and I agree there's no consequence listed in the election code. And the consequential cases that talk about notary misconduct, there has to be fraud. It's got to lie to a level of pattern of fraud. And that's where the courts step in, because, whether it was a robo notary, whether the people did not appear, whatever. I think one thing that's very important here is that we seem to be focused on Mr. Hauser as a part of the transaction. But I think one thing that has not been mentioned is that there are other candidates and circulators that appear, and you are going to negatively impact those individuals that properly appeared before someone they thought was a proper notary. And this goes to the decision that Mr. Kelly discussed, is you're going to invalidate candidacies based on Mr. Erdman's stretch of, and I'll call it, we take this step through these cases, but there is no consequence. And substantial compliance, if you look at substantial compliances, people appeared that circulated petitions in front of a notary. And there's no allegation that the notary, other than, what Mr. Erdman wants to claim, but there's not the standard allegations that allows the court to step in and strike the petitions. For that reason, there's substantial compliance. And this goes to the fact that, I didn't know the notary was expired. I didn't know that the notary was actually, not a notary, but, she forgot that her thing had lapsed. For those reasons, you have to take a look at the number of signatures, signers, circulators for all the other candidates that appear on these petition sheets. And I don't think there's any justification. And to harp on what Judge Bertucci said, it's just like Mr. Erdman wants a consequence that is not expressly stated, and putting candidates on notice or putting anyone on notice, this will happen. And for that reason, his argument doesn't hold water.
The idea that it's unfair to the other candidates on this petition is off point. These candidates bound themselves together, and they bound themselves together to gain the benefit of that association. And with the benefits of that association comes the consequences and any penalties for that association. The objector didn't force these candidates to bound together and place their names on the same petitions, just to accrue those benefits. That was their decision. It's if we want to talk about unfair and it's sad and all that, it's sad when anybody gets kicked off the ballot because they've made the effort. But incumbent upon them when they make that effort is that they comply with the laws of Illinois, both the election code and the Notary Act. And that hasn't been done here.
Mr. Erdman, any other comment?
Just to Judge Bertucci, that I am waiting for some type of case that involves Coach Ditka so that we can actually refer to Ditka Dicta
Members,
throughout any arguments, but that's it.
members of the board, I do want to point out there was a recent decision before the county officers electoral board in 19 COEB JUD 01. It was the objection of Peter Kramer to the nomination papers of Antoinette Weston for the Democratic Party nomination to the office of Judge of the Circuit Court of Cook County, 3rd Judicial Subcircuit, Peter Flynn vacancy. A hearing officer was appointed to conduct the proceeding, and as a portion of the hearing officer's case, he had to rule on an issue four square with the one before you. And the hearing officer pointed out that the objector argued that a portion of the voter affidavits contained in either or both Exhibit A and B should be barred because they were notarized by the candidate, Antoinette Wilson, who was claimed to be a party in interest. The hearing officer rejects the case cited in support of objector's position, Johnson v. Ames, 2016 IL 121563, as not having any precedential value on the candidate notarized affidavit issue. That case was resolved solely on the constitutionality of certain alleged vague language contained in a proposed referendum. The objector further argues that 5 ILCS 312/6-104B of the Illinois Notary Act states that the notary public shall not acknowledge any instrument in which the notary's name appears as a party to the transaction. Because the candidate's name appears on the affidavit notarized by the candidate, it is argued that she is a party in interest, since it is to her benefit to notarize and present the voter's affidavit supporting her candidacy. But this logic is not in accord with the case of Hill v. Municipal Officers Electoral Board, 92 CO 33, Circuit Court, Cook County, 1992, and followed by Smith v. Boyd, 99-EB-ALD-149, 1999. In Hill, the court held that nowhere in the election code does it provide for invalidating a candidate's petition because the candidate on those petitions notarized the circulator's petitions. A factual distinction argument may be made because in Hill, a circulator's petitions were notarized, where here a voter's affidavit was notarized by the candidate. But such a distinction would strain logic, since the main issue is not who signed the notarized document, but that the candidate's name appeared on the document being notarized by the candidate. The notary's job in such instances is to verify the identity of the signer, see Illinois Notary Act at 5 ILCS 312/6-104. Consequently, those affidavits contained in Exhibit A and B are admitted into evidence. Now that is a case that I was able to find that was issued notably by an electoral board subsequent to Johnson versus Ames, but found that, as I just read into the record, I'd be glad to provide that to all the members of the board if they would like to verify what I've just read. But I was just doing some quick research as a matter of course with respect to this particular proceeding. So that is something I thought would be important for this board to consider, given the questions that you've asked, as well as the answers that have been provided by the lawyers for the candidates.
Thank you.
What year was that?
I'm sorry, what?
What year?
That was a the board convened on January 21 of 2020. The case was filed. It had to be filed in 2019 because it's a 19 county electoral board judicial case. So the decision itself was the hearing officer's findings were made on January 15th of 2020, and the electoral board adopted his findings on January 21st of 2020. So
I'll acknowledge that the date is after the Ames case, but I would say that the fact pattern is different. And we're talking about an affidavit versus petitions, and Johnson v. Ames doesn't say that affidavits are instruments or affidavits are not instruments under, in the election process. They say that the petitions are instruments. So first off, it's not the same fact pattern. And second off, if a hearing officer after appellate court speaks, wishes to disregard the appellate court, they do that, and they do that at their peril. And if a board, adopts that recommendation, that board does that at their peril, because then the parties to that case have every right to go seek relief. It turns precedent upside down if we're gonna take a hearing officer's decision over an appellate court decision.
Is Mr. Ledin, I was going to say something, but Mr. Ledin, Stephen, do you want to say something?
No.
In cases like this where there's no appellate court or Supreme Court cases, it's very difficult to determine how it should be interpreted. And I will note that all electoral boards are equal. So it's not necessarily because one board does this, we have to do it. I think one way of looking at this is everybody's saying, shall, it's mandatory. But in election law, shall is used probably in every provision. And the courts have long recognized in election-related statutes that if the statute provides a penalty for noncompliance, it's mandatory. And that would be Simmons v. Du Bois, and that's 142 Illinois Appellate 3rd, 1077, 1986. And here, and looking at Hill, just for guidance, it does say that there is no remedy in the election code for what we have before us. Therefore, I could argue that it is not mandatory that a petition has to be signed, has to be notarized by someone other than a party or the candidate, especially if his signature is not in the lines on the petition sheet. I will state, I do think that it is an instrument, but I think we have to look at it a different way. I'm not going to disagree with Ames that it's not an instrument. I think it is an instrument, but I think here there's no mandatory remedy under the election code. And I think therefore there's no harm done. And I wouldn't necessarily think that the court would say that it's a mandatory provision for that reason.
That's a well taken point. And Ames, well, I think it gives us good guidance, dicta or not. While they describe the petition as an instrument, and it sounds like they would call Mr. We've been on this call so long, I forgot his name. Candidate, I'll say candidate. A party. Ames certainly is not telling us what they would have done in terms of actually striking them. Turning shall into mandatory when no consequences listed. So, that's well taken, Judy.
Thank you.
I think that I think Ames juxtaposes the petition versus a candidate with that intent in mind. is to say, this is what we would have done if it was a candidate. And if we go back to the use of shall under the election code and the case law about, whether there's a penalty specifically stated in the statute or not, that goes to the effect that if the word shall is used connected to an action, connected to a penalty, then there's no getting out of it, period. That doesn't stand for the proposition that anywhere that shall is used, go ahead and substitute may. That's
Right.
what those cases say. So, we can't ignore that. The shall and the penalty connection just says, look, you got no wiggle room here. Okay. Shall still means shall everywhere else shall is used.
Well, point well taken. Sure.
Or as they say, shall means shall, except in election law.
Ah,
Are there any other comments from anyone else with respect to this matter?
I'm still having a hard time with the penalty because there is case law in some earlier election cases, Meyer versus Kerner, which is from 1966, and Valentine versus Bardwell, which is from 1985. And both cases are still precedential. And they lay out the case that if something is going to be fatal, when shall is used and it's mandatory, you need to spell out the consequence for noncompliance clearly and expressly. And this is where I'm reaching here. The prohibited act in the notary code is applied to the election code. I don't see that it expressly states anywhere in the election statutes that we have to negate the entire petition based upon mistake or misconduct by the notary. And in that case, in the election context, when the word shall is used and there's a penalty for noncompliance that's going to result in invalidating a candidacy or the results of an election, the statute's got to say this is the penalty for noncompliance. And I'm not seeing that here.
That argument would invalidate every section of the election code where shall or may is used and there's no penalty listed. And that's obviously not the intent of the legislature. What we have is a statute that provides that if this is what they do, it's not valid. Then we go back to the election code and the election code says you have to do that. Well, if it's done in a way that it's not valid, it doesn't count. And we haven't asked that the entire, we haven't asked the entire petition. We've addressed the sheets notarized by the candidate. Now, if that, obviously that extends, but we aren't making the blanket statement that every other sheet is somehow tainted because of this process of the notary. We've made our very specific allegations to the sheets notarized by the candidate and how they're defined as an instrument, how they're impacted by the Notary Act, and then what effect that has under the requirements of the election code.
Okay, Mr. Ladizinski, this was your motion. Do you have any final comments you would like to make?
No, I believe we've had a very thorough discussion.
Members of the board, does anyone else have any final comment they'd like to make?
Not at this time.
Okay. At this point, Ms. Coleman, you're the chairperson of this particular panel on 2020 BIMOEB-01. Do you want to act on the motion to strike and dismiss the objection, the objector's petition in this particular matter at this point in time?
Yeah, I'll make a motion. I would make a motion to grant, are we doing the, to grant the candidate's motion to dismiss the
Is there a
objection?
second?
Pardon?
No, I'm sorry, I didn't, I said, is there a second?
Okay, based,
I might have cut you off before you finished the motion. I
okay, I
apologize.
would just make a motion to grant the candidate's motion to dismiss the objector's petition based on our discussions in open court and to be
Is it-
reduced to writing.
Is there a second?
I'm sorry, wait, I missed. Judy, what did you say at the end there?
That based on the discussion in open court and then reduced to writing.
Thank you.
Is there a second?
I'll second.
Okay, on the roll call, on the motion to grant the candidate's motion to strike and dismiss the objector's petition based on the discussion in the open hearing. Roll call. Ms. Coleman,
Yes.
Mr. Kelly,
Yes.
Mr. Bertucci,
I don't think I'm on one.
Yeah, he's,
oh, I'm sorry. No, you are not on one. Mr. Johnson, I apologize. You're on one. Can you hear me?
Yes, yes,
Okay. Are you voting to yes with respect to the motion to grant the motion to dismiss the objector's petition based on the discussion? Is that your vote?
yes, yes.
Let the record show the vote on the motion to strike and dismiss the objector's petition in 2020 BIMOEB-01 is granted and by a vote of 3-0. And the objector's petition in this particular matter is stricken. Now, we've heard argument which pertain to all of the remaining matters, so we'll go through them one by one. Okay, now on 2020 BIMOEB-03, 04, 5, 6, 7, 8, 9, and 10, the chair of the panel is Domingo Vargas. On 3, the public member is Daniel Kelly, and the other member is Alderman Dexter Johnson. On 4 through 10, the chairman is Mayor Domingo Vargas, and the public member is Judge Robert Bertucci, and the other member is Alderman Dexter Johnson. So we'll first go with 3 on 2020 BIMOEB-03. Is there a motion to grant, or is there a motion with respect to the candidate's motion to strike and dismiss the objector's petition?
I'll make a motion to grant the candidate's motion to strike and dismiss.
And
Is
I
there
will
a second? Who seconded?
Kelly,
Roll call. Mayor Vargas,
Aye.
Member Kelly,
aye.
Member Johnson.
Aye.
Let the record show that in 2020 BIMOEB-03, which is the petitioner's objection to the nomination papers of Josh Roll, that the motion to grant the candidate's petition to strike and dismiss the objector's petition is granted by a vote of 3-0. With respect to the case of 2020 BIMOEB-04, Felix Oliva, Thomas Erico, Hilda Rodriguez, Hilda Arellano, Mariela Esparza Castillo, and Patrick Ring against the the nomination papers of Charlotte Mitchell Brown. Is there a motion with respect to the candidate's petition to strike and dismiss the objector's petition?
Mr. Horvath, would it make sense, since we have the common board and 4 on down, to go ahead and do that?
If you're okay with that, Mr. Erdman, I certainly am. We could,
Yeah, for the record, I agreed that the 1 and 3 had different boards, and we should obviously make that clear. But I think with 4 through 10, we have the exact same board composition, and we consolidated the argument for all those, for those cases. I don't think that we need to go through one at a time.
okay, I'd be happy to do that. Mr. Letazinski, are you okay with that?
I am.
Okay. All right, so with both lawyers for the candidates and the objectors being in agreement, are there any members of the board that are in disagreement with proceeding in that manner? The board on this is, again, Domingo Vargas, Judge Robert Bertucci, and Dexter Johnson. Do any of you disagree on that?
No.
Okay, so is there a motion with respect to the candidate's motion to strike and dismiss the objectors' petitions, excuse me, the objectors' objections to the nominating petitions filed by Charlotte Mitchell Brown, Thomas Hawley, Louis Esparza Jr., Rich Webster, Bill Farrenwall, Gabriel McGee, and Lauren Trinidad in cases 2020 BIMOEB-04, 05, 06, 07, 08, 09, and 10.
I'll make a motion to strike and dismiss on behalf of all those.
Is your motion to grant the candidate's motion?
Yes, yes, it is.
Is there a second?
Johnson.
Roll call. Domingo Vargas,
Aye.
Dexter Johnson,
Aye.
Judge Robert Bertucci.
Aye.
Let the record show that the vote on the motion to grant the candidate's motion to strike and dismiss in 2020 BIMOEB-04, 05, 06, 07, 08, 09, and 10 is granted by a vote of 3-0. Those petitions or objections are dismissed. Members of the board, we have one other matter to hear. It's 1:30. This is a record exam line objection with respect to 2020 BIMOEB-01 to the nomination papers of Domingo Vargas.
Wouldn't that
Would
be
you like to proceed now or take a short break?
O2.
Excuse me, 02. I apologize. 02.
A point of
like-
order, though? I mean, not all of us have to be on O2. Should we recess 1 and 3 through 10 for another date? Because I know that we have to come back for the written decision.
We can certainly do that, yes.
Before
You're
we.
way in front of me.
And
You're
in
way
that
front of
regard,
me. If
in
you
that
like-
regard,
I'm sorry,
Carrie,
Judge.
can we do that by Zoom with you? Can we do that by Zoom on the future date with us
Yes.
signing, on the screen?
Yes, I'm certainly okay with that. Attorneys for the candidates, are you okay with that?
Yeah, I've
I'm
seen
okay with that.
in other boards that the decision is before the board members on Zoom, and they sign and hold it up, and off we go.
And then we scan it to Carrie and he can send it out. I have no problem with doing Zoom. It's just that.
Okay, so,
Carrie, you need to prepare something for us, so it's really your call,
okay,
time
let's,
frame.
would, Tuesday, excuse me, would give me an opportunity to at least prepare something with the hopes of having it make sense. Would Tuesday, January 22nd be on a Zoom in the morning at,
I have another hearing.
you do?
Yes,
All right.
it's gonna- yes. And I don't know how long it's gonna go. And then in the afternoon, I have an appointment.
Okay. What about, do you have anything available on like Monday, Monday in the afternoon, Judy?
I can do if it's before 5:30, I can do a Zoom. I have another hearing at 5:30, but anytime in the middle of the after, anytime Monday is fine with me. You're talking
Monday's
about
good
the
for me
20
as well, morning or anytime.
Mr. Ladizinski and I are in Markham at 6 o'clock.
If we were to do something at, let's say,
Monday morning?
Monday, like maybe, how about in the afternoon, maybe
I'm
2 o'clock? Would that be okay with you, Mr. Kelly and Mr. Bertucci and Judy? Would Monday
Yes.
at 2 be okay?
That's the 25th at 2.
Scott?
I'm in Norwich from 1:30 until I go to Markham against Frank Coppola, so I don't estimate that'll
All
get.
right, well, let's see.
But right before that, if we could do it earlier than 1:30.
You can do it a little earlier if you'd like, yeah.
Yeah, that would.
Would 11
But
o'clock?
what's a good time for you, Scott?
Anytime before 1.
Anytime before, and
11
Judy, would you be
How
available?
about like 11 o'clock or something like that?
11
Would that-
o'clock
Sure.
on Monday
Dan?
would- 11 o'clock on Monday works for me.
Judge?
Yes,
Okay,
that's
then
fine.
if we could just have a motion to recess the boards in 01 and then 03 through 10, excuse me, until January 25th at, what did we say, 11 o'clock?
Yes, so moved.
So move. I'll second it.
Roll call. Judy,
Yes,
Dan,
Yes.
Judge Bertucci,
Yes,
Domingo Vargas,
Aye.
Dexter Johnson. Dexter?
I'm sorry, Councilman. Did you
This is
say
a
11
motion.
o'clock?
11 o'clock on Monday.
Is it possible to do it earlier than 11?
Uh,
I'm sorry, I'm not doing court, but I have a doctor's appointment at 11:45.
okay.
I could do it 10.
So can I?
Unfortunately.
let's
well,
ask
all right,
Mr. Johnson first. What time you leaving?
I'll cancel my 10:30 and we'll just do it at 10 o'clock, okay?
I have a conflict until like 10:45.
Oh, okay. Then I won't cancel my 10:30. My 10:30 is a 15-minute conference call, so
How about 9 o'clock?
That's good for me.
9:30? 9:30?
9:30, how's that sound? Would that work for you, Dexter?
Oh,
Yes, sir.
This is gonna take a very short period of time.
I could do 9 a.m. I can't do 9:30. I have an appointment from 9:30 to 10:45.
I'm good at 9 a.m.
9, fine.
9's fine.
9 a.m.
Mayor
sharp.
Vargas?
Fine.
Yes, that's fine. It's okay. 9.
Okay, recess, this motion to recess the 9 boards, 01, and then 3 through 10 until 9 a.m. on January 25th. Roll call, Judy Coleman,
Yes.
Daniel Kelly,
Yes.
Domingo Vargas,
Aye.
Robert Bertucci,
Yes.
Dexter Johnson.
Aye.
Thank you all very much.
Will you be sending us copies of the decision to review?
I'm going to try to get them to you as quickly as I can.
Okay, all right,
All
thank
right.
you.
With Zoom instructions.
Okay.
So we shall be back.
We shall be back.
We'll see. We'll see.
We have, as I said, one other hearing to conduct today. Would you like to take a short break before we do so?
Yes.
What would work for the members of Board 2, which is Judy Coleman, Dan Kelly, and Dexter Johnson?
I would like a little break.
At least.
Half hour, 25 minutes, 20 minutes, whatever works.
Half hour?
Half hour, is that okay with you?
Everybody comes back will be half hour.
Wait, which case is that?
Case 2.
It's 02. It's the challenge to the nomination petitions of Domingo Vargas. It's a
Right, and I'm on that one.
You are. Are you on?
I'm not on it. I'm not on it, Jerry. This is Dex.
That's right. Dexter's off of that one. Bob and
Judy and Dan?
It's the three of us, yeah.
yes, the three of you. Yes, that's right.
Okay.
Yes. Yeah.
And I'm fine with whatever, but in terms of how long we should break, what do you anticipate happening when we start again?
We have the Rule 8 motion and the signatures, right?
No, procedurally, it's a sheet and line. We won't re-argue the argument from the other cases. The records exam is concluded. We filed a Rule 8. I haven't received a Rule 8 from the other side. It's a question of how to get records from the county and when we would come back for an evidentiary hearing. Is that jive with
I
what
think we have what we need. We'll just put in. I'm sorry. Go ahead, Bob. I didn't mean to interrupt you. Go ahead. Or Scott.
Yeah, does that jive with what how you see the what needs to happen next?
Do we need to come back for that one?
Pardon me?
Do we need to come back or can we just do it today?
Well, we have to go. There's a Rule 8 challenging
Right,
certain of the
signature.
signatures that the county overruled the objections on. And
Correct.
so
I understand that.
you as a board have to rule now on the Rule 8 objections or the information that's presented. That's my understanding of the way we proceed.
I understand. I mean, I'd be ready to rule, but Mr. Erdman suggested that he wanted to come back at another time. That's why I'm asking what.
Right. We've requested that that the board request records from the Cook County clerk.
We already have them.
We have that. We have.
We have what we need. We have what we need. We have the what do you call it?
We have the printout.
We have the packet. We have the summary report, the page report, and the signature clips. And so we have your Rule 8 objection, and we're ready to proceed. So let's just take.
We have we'd like to present affidavits. We'd like to have a handwriting expert testify.
That time has come and gone. We're ready to go. This is you're supposed to be ready to roll on this, and if you're not, board rules provide we proceed. You were supposed to provide anything you had to the board in advance per the board rules, and you were also supposed to provide it to the counsel for Mr. Vargas. And if you haven't, well, let's proceed on what we have, and we'll go from there. This is not something that we need to wait or delay any longer on. The ballot certification is due next Thursday. We're coming back here Monday for just to execute the decisions in the other cases. It's 1:40. We have plenty of time to complete what we're doing today, so let's go. We'll want to take a half-hour recess and then or 20, whatever works, but we're going to move forward. The rules are the rules, Scott. You should have read them the way everybody else did. Let's take a half-hour break.
Can
We'll come back here and we'll proceed.
Before you decide, Mr. Horvath, can we have a discussion in front of the board?
I don't know what there's to discuss. I think the board wants to proceed.
I've heard a question from Board Member Coleman. We requested documents in our Rule 8 that I haven't had a response to from you.
What?
We haven't, this is our first time back from having a new board constituted. There hasn't been a evidentiary schedule made. And we have plenty of time to resolve this matter before certification.
You filed your Rule 8 motion, okay? You attached what you were going to attach. The board has what it needs to proceed with respect to your Rule 8 motion. Per our rules, if you had other type of evidence that you were going to present, you had an obligation to present it to the board, okay, and to your opponent. If you don't have other evidence, that's not the board's issue. The board is here to rule on or to decide on your Rule 8 motion as presented. And that's what the rules say. And so there's no additional discovery that's necessary here. You must have had something with which to file your Rule 8 motion.
The Rule 8 motion is filed based on the rulings at the records exam, Mr. Horvath, and the parties appear and preserve their objections to the ruling of the Cook County Clerk's employee so that then they can come back and then afterwards provide evidence to support their objection to the finding of the Cook County Clerk's employee. Now, this board met for the first time today per Judge Taylor's order. Okay, so the exhibits that you adopted today included the rules. They're adopted as of today. If you want to attempt to use those to jam up the objector and not allow us to present our case, then what I would request is that you present that to the board and allow them to speak, as opposed to you deciding and telling me that that's what's going to happen.
May I ask a question? Mr. Lazinski?
Yes.
I haven't heard you weigh in. Are you prepared to proceed today?
Yes.
And Mr. Erdman, the board has indicated, we have all day to do this. Are you prepared to proceed? I mean, that's what Terry is asking you.
Yeah, and my answer is no, because I specifically asked for documents from the board that I don't have access to from the county clerk's office. They don't give us signature clips for all of the signatures reviewed at the records exam. And, the usual process is we get the records exam, we get back before the board sets a schedule for evidence to be exchanged and a date for an evidentiary hearing on the Rule 8.
Well, I will say this, there was a little mix up in these orders, but I think we all expected that we were proceeding today.
Yes.
That was my full expectation. So yes, we're meeting in a first time in a sense because of last week's order, but then we set it with the expectation that we'd get a proper order and we would proceed. And that's where I think Mr. Horvath is coming from. And me as a board member.
And I would like the opportunity to present the evidence that's usually presented in a Rule 8. And there's affidavits, there's a signature expert to be advised of. I don't, where's the prejudice? And after everything that has happened in this case, all the way back to Mr. Stevo, that obstruction after obstruction has been placed before the objectors to get a fair shake before the board.
There have been no obstructions placed before the objector to do anything the objector needs to do. And this board has what it needs to rule on the signature objections that the objector wants to present. The fact that the objector did not come prepared to present its evidence today is not the fault of the board, nor is it my fault, nor is it the fault of the attorney representing the candidate. The objector filed his or its Rule 8 motion. The objector is subject to Rule 8 of the board's rules. The objector should be prepared to proceed, and I'm presuming that there is some preparation, and I think the board should just proceed. The objector doesn't need to get records from the board or from anyone else to proceed on its particular petition. The board can hear what the objector has to say about the particular signatures and then examine them based upon the evidence it has in front of it. And once we reconvene, I will ask the board to accept into evidence the petition summary report, petition page report, and the petition detail report, which, as I understand it, the petitioner also, or the objector also has the information that's required, is included on those documents, and then we can proceed. There's absolutely no reason to move this. As you've heard earlier, Mr. Erdman and Mr. Ledizinski have incredibly busy schedules. I particularly have a very busy schedule. You are all here, and I think it's appropriate at this point that we just proceed on. So if we can just take a short recess and come back in a half hour, Mr. Erdman can get his information together and we can proceed.
The reports that you just listed, all of those reports are not distributed to the parties at the end of the records exam. So what you understand is not the case. So not having those, we asked for the signature clips to be obtained by the board. The Cook County Clerk requires a non-disclosure agreement from the board and the members of the board and all the parties participating, so that we handle those documents correctly. Okay.
You don't need
in our Rule 8, and there was no response from you as far as what action the board would take. So
you do not need the petition.
We would address that today. I don't think is misguided.
You do not need the petition clips to proceed, and I'm looking at a signed copy of the petition summary report, petition page report, and petition detail report that was in fact received by the objector's representative on January 20th of 2021 at 11:29 in the morning, which is at the point in time when this particular records review was completed, and you filed your Rule 8 objection. I believe it was that same day in the evening, early evening. And so we're ready to go. I'm just asking that this board take a half-hour recess to catch its breath, get its records together, and we'll come back. Can we have that? Can we recess for a half an hour? Mrs. Coleman, would you make that motion?
Yeah, I make a motion that we recess until 2:30.
Second that motion, Mr. Kelly?
Yes.
Roll call, please. Ms. Coleman?
That's closer to 40 minutes, but I'm fine with that.
Oh, I'm
I'm
sorry, I was
okay.
just trying to even it. By the time we get off, it will be 2:00.
Yeah, I mean, that's fine. I'm just saying, I'm flexible and whatever the party, everybody needs. So I just pointing that out.
Ms.
You wanna-
Coleman, roll call?
Yes,
Mr. Kelly?
Yes.
And Judge Bertucci?
Yes, 2:30.
Okay. We'll see you all at 2:30. Thank you.
thank you.
All right, thank you. I'm gonna get off Zoom, I think.
Yep.
You're muted, Judy. Dan? Don't choke.
That took a long time.
Don't choke, please. Let's see.
So, Larry, I have a question for you.
For me,
Why do you have 2 doors in your office?
why do we have what?
2 doors.
That's actually a conference room behind me,
Mm-hmm.
and they told me that was my extra space, but I don't ever get to use it. And so, but no, that's one of our conference rooms, and that's the reason.
Okay.
It's a really nice room too. It's a really,
Are you in the new building?
yes, I'm in the building. This used to be a Curves, and upstairs was a big printing, or an establishment that had a big printing press. And when we first moved in here, it was still up there. And during the day, it was like having a hammer over your head. Boom, boom. I don't know what it printed, but it was certainly loud.
I haven't been down there in a long time, so I never saw it.
But yeah. And then John is in the same building with us, John Murphy, and Amber.
Mm-hmm.
She's upstairs in the back.
Do you ever see John? He always keeps to himself with the door closed.
He's usually the one that's in that office back behind me.
He always uses space.
Yes.
He always took over our conference room also, so it's no different.
Okay, let's see. Go to. Let's see.
Unmute. Okay.
Are we right back? Oh, there it is. Okay. All right.
Oh, now you're sitting in the sunshine.
For me,
You
Yeah,
look
the-
like good,
in the afternoon.
right? Good. I
It
did that
feels
early.
good though.
Yeah, it's really chilly out.
I know, but this way I don't have to keep, every time I reach over, I have one of those radiators that you turn on and it gets really stuffy and then I have to turn it off and then, so hopefully I won't have to do that.
Okay, looks like we have everybody present.
I'd like the opportunity to address the board before we start.
Why don't we reconvene and then you can address the board? How's that sound?
Perfect. Perfect.
All right. Let the record show, my name is Kerry Horvath. I am the attorney for the Municipal Officers Electoral Board for the City of Blue Island. It's January 22nd at approximately 2:35 p.m. The board is reconvening after a 40-minute recess. It is now reconvening with respect to the objection to the nomination petition of Domingo F. Vargas. It's in the matter of the objections of Solomon Esparza and Octavio Carbajal, petitioner objectors versus Domingo F. Vargas, respondent candidate, case number 2020 BIMOEB-02. Would the members of the board please identify themselves for the record, please?
Robert Bertucci, public member.
Judith Coleman, public member and chair.
Chair, sorry, I had to jump ahead of you,
Yeah,
Chair.
really, next time.
And Dan Kelly, would you?
Neil Kelly, public member appointed by the Circuit Court of Cook County for the Blue Island Electoral Board.
And would the parties through their attorneys identify themselves?
Scott Erdman on behalf of the objector.
Stephen Ladisinski, LAD-UZ, INS, on behalf of the candidate.
And then let the record show that also present and conducting, monitoring this particular proceeding is Randy Heusser. And Mr. Vargas, would you identify yourself for the record, please?
Good afternoon, everyone. Domingo Vargas here on Zoom for the election board hearing.
And then there's also a court reporter present. Her name is Maureen Nagel. What I'd like to do initially, and then Mr. Erdman, you'll be allowed certainly to address the board, is we call this matter to order. And it is being conducted by Zoom as we did earlier today with respect to the other objections that were pending. This matter was first brought before the Electoral Board on January 8th. It was continued for hearing to January 19th. Initially, there was a record examination scheduled in this matter for January 14th of 2020. It was rescheduled to January 20th because there was a motion pending before the Circuit Court of Cook County, and the objectors wanted to wait for a determination on that particular motion. The board, at its initial hearing, admitted into evidence exhibits 1 through 7. And what I'd like to do is go through those exhibits with the board They were Exhibit 1, the objector's petition. Exhibit 2, the candidate's nomination papers. Exhibit 3, the call of the Electoral Board. Excuse me. Exhibit 4, the agenda for the initial hearing. Exhibit 5, the proofs of service, waiver of service, and appearances filed by the parties. Exhibit 6, the rules of procedure. And at that time, Exhibit 7 was the Circuit Court Special Order 2020-53, appointing public electoral board member and public member oath of office. That was with respect to Daniel Kelly. At this point, I would ask the board to readmit into evidence Exhibits 1 through 6 as stated, and Exhibit 7 will now include as part of Exhibit 7, Special Order 2021-20 revised, signed by Judge Sanjay T. Taylor and entered by the Clerk of the Circuit Court of Cook County on January 19th, 2021, setting forth the membership of this board and other memberships on other on boards hearing other objections in this particular before the Blue Island Municipal Officers Electoral Board, as well as an order entered by signed by Judge Sanjay T. Taylor and entered by the Circuit Court of Cook County Clerk Iris Y. Martinez on January 15th of 2021, setting forth again in detail the Electoral Board membership and indicating which members could serve on which board or would serve on which boards and who was disqualified from those boards. And then also part of that was an order spread of record in 2021 COEL 000001. Felix Oliva et al. Versus the Municipal Officers Electoral Board of the City of Blue Island, entered of record by Judge Sanjay T. Taylor, or signed by Judge Sanjay T. Taylor on January 12th and entered of record by the Clerk of the Circuit Court on that date. Could I get a motion to accept Exhibits 1 through 6, as well as 7, which includes the 3 documents that I've referenced, along with what was previously admitted? A motion to admit and accept those Electoral Board exhibits into evidence.
I would make a motion to admit and accept into evidence Exhibits 1 through 6 and the revised Group Exhibit 7 into evidence for the board.
A second, please. Is there a second?
Second.
Motion by Judy Coleman, second by Judge Bertucci. Roll call. Member Coleman?
Yes.
Member Bertucci?
Yes.
Member Kelly?
Yes.
Exhibits 1 through 6 and 7 as amended are accepted and admitted into evidence as board exhibits 1 through 7. I would now ask that the board consider a motion to adopt and incorporate by reference the results of the record exam conducted by the Office of the Cook County Clerk into the record in BI MOEB-2020-02 as exhibit number 8. Can I get that motion?
I do a motion to accept as evidence and enter into the record the petition summary report and all the other documents from the Cook County Clerk in regard to the records examination as Group Exhibit 8.
Can I get a second to that motion to accept into the record as Exhibit 8 and incorporate by reference the petition summary and attached documents prepared by the Cook County Clerk with respect to the records examination in BI MOEB-2020-02.
I'll second.
Motion by Judith Coleman, second by Daniel Kelly. Roll call. Member Coleman? Member Coleman?
Yes. Whoa, what happened here? Sorry.
Member Kelly?
Yes.
Member Bertucci?
Yes.
Exhibit number 8 is admitted into evidence as part of the record. Now, Mr. Erdman, you did have a matter that you wanted to, a preliminary matter you wanted to address to the board.
Yes, the procedures and the proceeding with the evidentiary hearing before this board is to ask that it move forward now is prejudicial. It goes against the practices of boards that Ms. Coleman sits as the attorney for, that she's appeared before. Mr. Bertucci, you've sat on boards and you've watched this happen. There is no, the only point in the rules that you can point to is Rule 2 saying that they may be required to present their cases. Okay. Good cause shown will allow that to be extended. We have filed our Rule 8 motion, and our Rule 8 motion requests that this board schedule an evidentiary hearing. Now, the board can either deny our request under the Rule 8 and would have to rely on good cause to do so, or grant it. And if they grant it, then what due process would be relied upon to say, we're granting your request for an evidentiary hearing and it starts in 5 minutes because this board was just constituted. The rules contemplate a request for subpoenas. There has been no allowance for us to request subpoenas or opposing counsel to speak towards those requests and the board to rule on them. The assertion by the board's attorney that I have had signature clips since the records is again finished is just wrong, period. It's wrong. The Cook County clerk does not issue reports from the records exam that include signature clips at the end of the records exam. They do not do that. Their policy and procedure is that the parties have to submit a non-disclosure agreement before they'll do that. Now, without the board being constituted and proceeding, to allow that to happen precludes us having those before us. Those signatures, the clips that the clerk relied upon to make their ruling, need to be available to us for us to make our arguments. Further witnesses that we would ask to appear at an evidentiary hearing would have no notice of when an evidentiary hearing would be conducted because the board hasn't met until today to rule on the Rule 8 motion and schedule an evidentiary hearing. So the position of the board that this has to go forward today because the ballot needs to be certified just flies in the face of due process and the rules and can't even start until a request in the Rule 8 motion is ruled upon.
Before I comment to the board, Mr. Ladizinski, do you have anything to say in response?
I actually do. Can you hear me?
Yes, I can.
Okay. The issue is these are expedited proceedings and the records exam results and the petition summary report and the individual rulings upon which the objectors based their Rule 8 on was in their hands from January 20th. The way you do this, if you want to challenge a signature, is to go and get affidavits saying they either signed it or they didn't sign it. Someone else signed my name. It's not my signature. And that's for signature. On registrations, if someone's not registered, they're able to go get that information from the clerk. The rules require the objectors to bring affirmative evidence forward. And what I get the sense of is what Mr. Urban wants to do is have this board spend countless hours reviewing every decision made by the Cook County Clerk's office in an effort to overturn decisions. And that smacks against Rule 8 and the case law. If there's obvious errors, his observers should have noted those. And, he'd be able to say, hey, this is clearly an error. Here's an affidavit, but he's not done that. While we talk about this board has just been constituted with these members, he knew when the initial call, what his case was. And, it's a records exam. So, if he didn't believe that he's taken by surprise somehow that there's going to be a Rule 8 hearing after the records exam, these move fast and furious. So, I appreciate, his dilemma. He wants to buy time. It is the 22nd. I don't want to belabor my point of, I'm from hearing to hearing, even on Saturday and Sunday. And I'm ready to go today.
And members of the board, I want to point out to you first, I don't think I said Mr. Erdman had the signature clips, but he did have a copy of the reports that were provided to the candidate representative and the objector representative at the time of the record examination. But on January 8th, when we first met, it was clear and made clear in the record, because of the nature of the objection, that a record examination would be conducted. And we actually had one scheduled for January 14th of 2021, but Mr. Erdman determined that he did not want to proceed at that point in time. He wanted to present and get a ruling from the court, the trial court, on a pending matter. And so we had to reschedule it, which is what we did, but he was fully aware of this. Our rules do state on page 1 on page 2, on the date set for hearing of objections, both the objector and the candidate may be required to proceed to present their cases. There will be no continuance or resetting of the hearing on objections except for good cause shown or the discretion of the board. Good cause is not, I'm not ready to proceed. The other thing I wanted to point out is that the determination per our rules and per pending case law, as I understand it, is the determination made by the clerk's office of the validity of this and genuineness of the signatures is presumptively valid unless an objection is raised and further proof is submitted. And if that proof exists, Mr. Erdman should have been able to present that proof at the time when he filed his objector's Rule 8 motion, indicating on the pages attached to it which signatures he was going to challenge, because we're supposed to file these pleadings in good faith. That's one of the conditions of the rules, is it's expected that the pleadings that we file are filed in good faith, as if this were a legal proceeding in front of a court. There's no difference there. And so something had to trigger the ability to file this motion. So coming here today and saying, well, I don't have what I need, well, that's just not a viable excuse given the nature of these proceedings. And this board is prepared to proceed. And my advice is that we proceed. And you don't have to go through each and every signature on the clips and compare them to the petitions if the objector is not prepared to proceed and present evidence establishing at least something to indicate that the signature might be questionable. So this is where we stand right now. it's Mr. Erdman's case to present. And at this point in time, based upon the summary report, Mr. Vargas has sufficient signatures with respect to his petitions. And so, Mr. Erdman, if you're not prepared to proceed, please let us know. But the bottom line here is the board should proceed to conclude this matter. It's not a denial of due process. Due process has been underway since the call of this particular board was first initiated. And I don't think I need to say anything further.
I do. I think I need to say something further. Our Rule 8 was filed in good faith. If you want to accuse me of making a filing in bad faith, please clearly state that now. Okay? Otherwise, we'll move on and we'll forget that comment. Our Rule 8 preserved the signatures that we wanted to move forward on with an evidentiary hearing. They weren't every single one that we lost. We evaluated and we chose the ones that we wanted to place before the board. We've done so in a properly filed Rule 8 motion, okay, that hasn't been before the board until right now. Now, if the board wants to rule on it, then rule on my Rule 8 motion and either deny it or grant my request for an evidentiary hearing. And for the record, if you want to grant that evidentiary hearing and schedule it for right now, then that's the board's prerogative. Now, that would preclude me from issuing subpoenas, having people come in to testify, and requesting the documents that I want from the Cook County clerks through their procedure, which includes the signing of a non-disclosure agreement by the parties involved. If that's what you want to do, Mr. Horvath, and that's what you want to recommend to the board, then let's move on and we can settle this one and we'll tee it up for whatever is next.
Mr. Erdman, are you prepared to proceed?
I'm ready to be heard on my Rule 8 motion.
Are you prepared to proceed to present the evidence required to sustain your Rule 8 motion? The board is here to hear your evidence. If you don't have evidence, please be honest with the board and explain that to them. If you do, let's proceed.
I just did, Mr. Horvath. Are you granting my request for an evidentiary hearing? Are you scheduling it? And if
The board is here to conduct an evidentiary
right
hearing.
now,
Yes.
go ahead and state that for the record.
I just said it. The board is here to conduct an evidentiary hearing. They are prepared to proceed.
Okay.
Are you prepared to proceed?
I would like to request subpoenas. That's how I'd like to proceed.
Why didn't you request the subpoenas 2 weeks ago when we initiated this proceeding, Mr. Erdman?
Because we don't
Back
have
on
a
January 8th.
constituted board to submit those to. That's not the normal process, regardless of what you assert. This board wasn't constituted to hear a request for subpoenas before today. They weren't constituted to hear any possible objection by Mr. Ladizinski, who's free to waive his end of due process, but not mine, and rule on those, have those subpoenas issued and served with a date and time certain for them to return.
Well, Mr. Horvath, this is Steve Ladizinski. I'm at a loss what subpoenas would be necessary with regard to a line-by-line objection. Is it Mr. Erdman's effort to subpoena 70-something people, 64 people to come in to testify?
It's not Mr. Ladizinski's place to craft my case for me, and it isn't Mr. Horvath's, who's already gone on record saying that I have everything I need to proceed. It's not his place to make that assertion, and it's not Mr. Ladizinski's place to make that assertion.
Well, I mean,
There are allegations beyond signature in line. There's allegations as to who signed first. There are other issues here. There's the ability for us to bring a handwriting expert before the board. There's the ability for the board to evaluate the credentials of that writing expert.
Yeah, but they haven't, but
Mr.
there's,
Ladizinski to object to the credentials of that. The fact that we want to jam this through as fast as possible isn't a reason to ignore all of those issues.
Mr. Erdman, no one is jamming anything through.
You are.
No, this is your objection. You've had the petition, the petitions were filed in December, if I'm not mistaken, but regardless, you've been involved in this from the very beginning. When we initiated the hearing, you were involved there. When we first met, we discussed the need on January 8th for a record examination by the Cook County Clerk. You objected to the record examination that was originally scheduled for January 14th. For what reason, I do not know, because it had nothing to do with the issues that were pending in the circuit court. You objected, and so we couldn't go forward. You then filed your motion and attached what you claim are, at least on their face, 64 objections made in good faith. If they weren't made in good faith, well, that's your responsibility to, as a lawyer, to make a pleading that is done in good faith, which you believe you can prove. You're not prepared. I'm reading it this way. You are not prepared to present proof today. So it's up to, it's the board's call. My advice would be for the board to proceed with the hearing today on this particular objection, given the record as it exists.
As one board member, I would say I think your analysis is correct, Mr. Horvath, that we should proceed. Now, obviously, something could occur. Oh my God, it's my dog. There you go.
Does he get a vote?
And, you know, obviously, if something jumped out at us, we would consider it at that point. But as we sit here, making a decision about whether to proceed, I think, as I said, your analysis is correct. And with all due respect to Mr. Erdman, I would indicate we should proceed.
Do you make that motion, please?
Can I
Yes.
make a comment before we make motions?
Would you make the motion to proceed with the hearing on the objector's Rule 8 motion and the objection to the petitions, nominating petitions of Domingo Vargas in case 2020 BIMOEB-02?
I'd like to make a comment before I make a motion.
Certainly.
Okay. It seems his Rule 8 motion, he sets forth the rulings that are in question. I mean, I think the board should just look at those signatures that are in question and compare the, I mean, we've done this before where we just compare the petition sheets to the clips from the county.
I'm sorry, I didn't hear that last comment, Judy.
I've
Where you
sat
said
on
we've
boards-
done this
I've-
before.
I've sat on, yeah, boards before where we'll look at the petition sheet and what he's disputing for his Rule 8 motion, look at the petition sheets and then compare it to the clipped images from the Cook County records exam.
That's your prerogative as a board.
Then let's do it. Let's create this record, Mr. Horvath, and let's move forward line by line, and let's finish it.
Can I?
We have a motion.
We don't have it yet.
Is there a motion to proceed and a second? I need that to go forward.
I'll do a motion to proceed with the Rule 8.
Okay, second. Is there a second?
Second.
Roll call, please. Roll call. Miss
Judy, yes.
Judy, please.
I'm gonna give you my,
Judy
my
Coleman.
married name.
Judy Coleman, yes. Mr. Bertucci,
Yes.
Mr. Kelly.
Yes.
Okay. So, and Mr. Ladizinski, did you have something else that you were attempting to say before I asked for the motion call? I wasn't sure if you said something or not.
Yes, the rule requires him to present evidence.
I understand that.
And my concern here is, being through an effort that occurred last cycle of 24 hours of trying to rehabilitate signatures by a candidate 800 below, that went on for 3 days, 24 hours total. It is my position that without affirmative evidence offered by the candidate, this is improper, but that's my objection.
And I believe you are correct. The rules require indicate that the signatures are presumed valid as to registration status and as to genuineness of signature and as to all other findings made by the clerk or electoral board attorney, unless an objection is raised at the time of the decision by the election authority and further proof is thereafter submitted to the board. So, Mr. Erdman, you have a responsibility to present proof. Do you have any additional proof to present to the board?
Yes, I'd like you to provide the board the report that includes the signature clips, the basis of our recording objections, which were a subset of all of the ones that we lost, is that we don't believe they match.
The board has that information.
I'd like to finish.
I'm sorry, I thought you were finished.
The board can proceed and review those signatures if they wish. Ms. Coleman has already indicated that has been done before. And if that is the only avenue that you are going to leave me at this time, then that's the avenue we'll take. That is evidence. It's been, you entered that into the record and we're going to rely on that. So let's move forward.
Mr. Erdman, I didn't leave you any avenue. I think you chose the avenue you wanted to proceed on. I'm simply asking you now, do you have any evidence to offer to the board in addition to what is presently before it?
You just asked and I answered.
Do you have any evidence in addition to what is before the board?
I've placed my evidence before the board.
Members of the board, I'm going to accept Mr. Erdman's statement that he has placed his evidence before the board. He has not offered anything in addition to either myself or to the attorney for the candidates. Has he offered you anything, Mr. Ladizinski? Excuse me.
No.
He has not offered anything to myself or the attorney for the candidates in addition to the document he has referred to as a Rule 8 petition. As I indicated per our rules, the signatures are presumptively valid. You can accept the findings. The Cook County Clerk as set forth in the petition summary report, indicating that the minimum signatures required are 126, that Mr. Vargas's submission has 76 signatures greater than the required minimum, that there were total pages of 33, there were total signatures of 290, there were total objections of 202, there were total ruled on objections of 202, there were 88 sustained lines, there were 93 overruled lines, there was a objection for review of 88, there were 202 valid signatures, there were 109 total unchallenged signatures, and there were 76 signatures greater than the required minimum. That is now in evidence. You do not have to proceed further unless additional evidence is presented by Mr. Erdman to support his Rule 8 petition. If he has none, then you can make a motion to deny the objection as presented, and I will prepare a written order to that effect. Is there a motion at this point in time?
Could I ask a question?
Sure.
I wanted to ask a question of Mr. Erdman. You said you were requesting an evidentiary hearing, but in effect, your arguments today have been for a continuance. What is there good cause shown? Is there any explanation you've got why you couldn't speak today?
The process that 99 out of 100 boards follow is you return from the records exam, the Rule 8s are filed, they come before the board, and an evidentiary hearing is scheduled. At which point it's down the road. The parties can exchange affidavits, other evidence, call handwriting experts to appear before the board on signatures that they want to rehabilitate. All of that stuff happens in due process after a Rule 8 is filed and a hearing is requested and scheduled.
Okay, but
That's not what's happened here.
Have you collected any affidavits, or have you identified an expert witness who was going to testify about handwriting?
We have both, but have we had, this is our first hearing back from the Rule 8 and from the records exam and the filing of our Rule 8. It not only is our first hearing back from that, it's our first hearing period.
But if you knew the name of a handwriting expert witness, did you disclose it to the board or to your opposing counsel?
No, because this just started. Mr. Horvath's, contention that because we started so long ago, I should have all of this dumped on the board the first day. It's ridiculous. If we wanted to have this move forward, then we wouldn't have been forced into the circuit court to get Mr. Stevo removed in the first place. So if Mr. Horvath wants to claim delay on my part, he can take his own responsibility for the portion of delay that he caused.
If I may.
And we can all go ahead and claim to be offended and, as much as you want. So
I'm not claiming to be offended at all, but what I'm informing is this board is that nothing has been presented per our rules. No witness lists have been presented. No evidence has been presented. Wishing doesn't make it so. And the bottom line, the objector is supposed to be prepared to present its case on the date set for the hearing. Now, we've gone through this, we've gone through the history. The signatures are presumptively valid. There's nothing that precluded Mr. Erdman from being prepared to present his case. And I'm suggesting to the board that you do not have to go beyond what you now have in front of you at this point in time. I'm not trying to argue with Mr. Erdman, and I'm not trying to deny him any of his particular rights. He knows what his rights were, and he knows what the rights of the objectors were, and he's known that from day one when he initiated this process.
And the board is also free to follow the procedures that all the other boards around follow, Mr. Horvath, and set an evidentiary hearing and dates for exchange of evidence.
May I say two things in that regard? One, the same was true of the case we just handled for 4 hours, that in effect, this was our first hearing or first constituted board because of the basically a scrivener's error or a mistake. And yet we proceeded earlier without objection. Secondly, I don't know about 99 or 98%, but not on ones I've been on and not on the one I decided or with others yesterday in Riverdale, where we set the hearing date and there was a record exam in the interim, and there were Rule 8 motions filed each way. And when we got to the hearing, we proceeded on them.
And
Yesterday's case is in the same posture as this case is.
and I would
I don't find it to be unusual.
I would assume that between the call of the case and the date for the hearing on the Rule 8, there was much more time than has been this board has been constituted. I appeared on the other ones and made my arguments on legal arguments in good faith, because that's the process that's followed. I stood up ready to argue, and I argued. So, you know, that those cases, you know, show that I'm ready to move forward in good faith. I argued those cases.
Fair enough, but the exact constitution of the board doesn't dictate what evidence we're going to have to present to that board. We know a board is coming, and we know our case is pending, and we know what evidence we have. And so the exact numbers that make it up, our evidence shouldn't be a function of that. So,
well, and Judge Taylor's order allowed the briefing schedule to remain in place, and that was it as far as the activities of the board. We're now here. The board is met. It's time to proceed in an orderly fashion, which would include my ability to present an expert witness, to provide affidavits, all those things, without 2 hours from the time that the case is first called.
Well, I wanted to comment. I've been a member of the Electoral Board in this city since the first meeting was convened since my appointment, which was January 8th. And there's a portion of the preliminaries where the introductions are made and the rules are adopted. There was no discussion or questions or objections about the rules, and they were adopted as presented. I could see a continuance for good cause shown, but I haven't heard any in terms of preparation, in terms of the expert being on another job and not being available. And it's just, the thing is, I'm not unsympathetic, but I'm looking at the results of the records exam at the county clerk, and you're going to have to like clear like 86%. You don't have a big window to upset the results. The candidate is over by a significant number of signatures. And as I said, you're going to have to win on average like 86% of the 88 signatures that you've reserved for further review.
And included in our Rule 8 is that certain signatures beyond the maximum that can be submitted not be counted, and those are included in that report. So we have, you know, the idea that there's nothing to be presented, there's no process to be followed. That's one example of why this process needs to be followed, because there are your assumption is that there are signatures valid that make it impossible for us to proceed, when our Rule 8 specifically identifies why that number is high and what we're actually working with.
Members of the board, I think you're in a position. I'm sorry, I didn't mean to interrupt you, Mr. Kelly. I apologize.
It's just something though, like, I believe if I read the precinct summary report correctly, there's been 88 signatures challenged by objection by the objector for the board to consider, and the candidate's over by 76. I mean, we're going to do this for the sake of exercise. If we would sustain the findings of the county clerk's workers, you don't have a very big window of opportunity to upset the findings that were done at the election center in Cicero. And I mean, if you've got some outstanding evidence or something, or you've had some people out in the field ringing doorbells, we should know that. But if you don't, we don't have the luxury of giving you 2 weeks to go out and conduct a field investigation.
That's not what I'm asking for.
All right, I'd like to say something. I actually made an independent review yesterday of the spreadsheet Mr. Erdman presented of what he was challenging. with the signatures that we were provided by the Cook County clerk. And at most, and that's still questionable, maybe, my conclusion is maybe 5, 6, or 7 may be wrong, and that would still not be enough to change the results. I mean,
Members of the board.
Mr. Horvath's arguing against an evidentiary hearing, and we're hearing evidence from 2 board members as to whether we have we even have a chance of succeeding, and another board member as to what she thinks the final number is. I made my case, and respectfully, I'm ready to move on.
I think that at this point in time, members of the board, Mr. Erdman has no additional evidence to present. He's made that pretty clear, even though he has not fully admitted that fact. I have not.
Don't speak for me, Mr. Horvath. Don't speak for me.
Well, I haven't seen anything, and you have a responsibility to present it by the rules. So at this point in time, I have not seen any additional evidence presented by Mr. Erdman in accordance with the rules. The rules indicate, and as I've stated earlier, the signatures are presumptively valid unless contrary evidence can be presented. There is nothing to present. I think that Ms. Coleman's remarks are appropriate. I believe Mr. Kelly's remarks and Judge Bertucci's remarks are appropriate. You are in a position at this point in time, you've indicated there is a hearing scheduled. It is not a denial of an evidentiary hearing. There was an evidentiary hearing scheduled for today, and Mr. Erdman should have been prepared, and he is not. And so you can move to overrule or dismiss the objection as presented. I can prepare an order to that effect, and we can present it at the same time that I'm going to present the order in the other 9 matters, or the orders in the other 9 matters coming before you again on Monday morning. I don't think there's any further discussion that is required unless you have other things that you would care to indicate for the record. Would one of you be kind enough to make a motion?
Move to accept the precinct summary report as compiled by the Cook County clerk in this matter.
Second.
Roll call, please. Member Coleman,
yes.
Member Kelly,
Yes.
Member Bertucci.
Yes.
Is there now a motion to overrule the objection filed to the nomination petitions of Domingo F. Vargas in the matter of the objections of Solomon Esparza and Octavio Carbajal versus Domingo F. Vargas in case number 2020 BIMOEB-02?
I'll make a motion to overrule the objections filed.
Is there a second?
Yes.
Second.
Motion by Public Member Coleman, second by Public Member Bertucci. Roll call. Public Member Coleman, please.
Yes.
Public Member Kelly.
Yes.
Public Member Bertucci.
Yes.
Let the record show that the members have voted 3-0 to accept the report of the Cook County Clerk as stated previously in the record and is admitted as Exhibit 8. And the members have also voted 3-0 to overrule the objection in case number 2020 BIMOEB-02. The objection is overruled and dismissed. This matter is over until we have a motion to recess until January 25th and we're going to reconvene at 9 is it 9 a.m.
Yes.
for the other matters?
That's it.
We have a motion
The
to
same
do
as
that
the
in
other
this
ones?
case.
Yeah, I'll make a motion to recess until January 25th at 9 a.m. to to approve and adopt the written decision.
Thank
in
you.
order.
Is there a second?
Second.
Motion by member Coleman, second by member Bertucci. Roll call. Member Coleman,
Yes.
member Bertucci,
Yes.
member Kelly.
Yes.
Thank you all very much. Mr. Erdman, thank you. Mr. Ledizinski, thank you.
Thank you, everyone.
Court Reporter Nagel, thank you very much.
Are you going to be sending another link for Mondays?
Yes, we will.
The Zoom
Randy, can I ask you a question on the Zoom while you're on? Do we need a different Zoom call-in, or can we still use the one we have?
Maureen, Randy Hoyser, City Clerk. To be the same Zoom information, yes.
Okay. Does everybody have that?
Okay.
And Judge Bertucci,
Yes.
your swinging camera made me think that you fell down several times. So
Ha, I actually did fall down the stairs shoveling snow, and that's why I'm standing up right now. But no, I'm moving around a little bit.
okay.
Hope I didn't distract you. Tell you're on the ball.
Well,
Thank you.
all very much. Have a good weekend, and we'll see you or talk with you all on Monday.
Thank you.
Thank you.
Very good. Have a great weekend, everyone. Thank you.
Thank you.